Wording, purpose, and absurdity. Let me start with wording. There's been a debate before the court about the purpose, intention of the legislature in drafting the provision. Well, we say the wording itself does the necessary work. It makes plain that there are two things happening in the section. The first is the governing provision, and we've heard that already today. It tells this court what the drafters were concerned about. They wanted to preserve the integrity of the National Assembly. We reiterate, they wanted to preserve the integrity of that body. And so the section provides for disqualification of serious offenders from that august body. The second is the proviso. The proviso is a timing proviso. It simply regulates the timing of a disqualification where an appeal is available. And we know that from the wording. It uses the word until twice, and it links the word until to an event in time, until an appeal has been determined, or until the time for an appeal is over. With great respect to our learned friends, the respondents want to reread the proviso to give Mr Zuma an immunity from that section's disqualifying power. To them, you can't be disqualified from Parliament, or can't be regarded as having been sentenced, unless you've had an appeal. And worse, they want to read the section as saying that you can't be disqualified from Parliament unless you've been afforded a right to an appeal. But with great respect, that interpretation would absurdly exclude sentences imposed by the apex court from serving the section's substantive purpose of disqualifying constitutional delinquents from office. And this court in Zuma 2, the contempt judgment, was emphatic. It said, in direct access cases, the Constitution itself has made clear, and I'm quoting, the right of appeal simply does not exist. So there's no right that we're speaking about. Mr Zuma appears to want to relitigate that point. We'll come back to that. But the first and obvious point I stress is that the respondents have turned until into unless. But the drafters of the Constitution didn't use the word unless. They used the word until twice. And all that until does grammatically and by its purpose is it speaks to the timing. Until any appeal rights have been exercised, you're safe. That's because Section 47 contemplates a sentence that is final. But where that sentence is imposed by this court, as the court of first and last instance, then it is final. The constitutional structure makes that clear, and the disqualification comes into operation immediately. Now, such a reading serves the purpose of the section as well. The Electoral Court's interpretation of the section subverts that purpose. And it's no trifling subversion. It's a subversion that threatens the rule of law. Justice Bilkis asked, what is the purpose? It's to preserve the rule of law. That's because of the purpose in that disqualification. It is a democracy-affirming one that serves to preserve the integrity and the sanctity of constitutional office. And we've highlighted that purpose by the cases we've referenced from the European Court of Human Rights in our submissions. I don't have time to go through them. But coming home, we know that the eligibility criteria in the section shares that salutary aim to protect South Africa's democracy. From what? From persons who are unfit to be part of the special institutions that make up our Constitution. And here the important role of the National Assembly cannot be overstated. This court said so in the Nkandla judgment, and I quote again, it said in sum, Parliament is the mouthpiece, it's the eyes and the service delivery ensuring machine of the people. No doubt it's an irreplaceable feature of good governance in South Africa. And said this court, it's the embodiment of the centuries-old dreams and legitimate aspirations of all our people. We say that the interpretation by the Electoral Court subverts that purpose to give that institution the sanctity it deserves. It entitles a person that's sentenced by this court as a court of first and final instance to escape that disqualification. And as we've said, what the Electoral Court, with great respect, has missed is that the purpose of the proviso does something different. It doesn't qualify the substance. It doesn't add rights to the substance. All it does is it ensures that the substantive disqualification kicks in when that conviction and sentence is final. So it merely facilitates the question of timing. And in virtually all cases of criminal convictions and sentence, we know finality occurs at the time when an appeal has been decided or the time for an appeal has passed. But this court is different. In the case of an apex court against whose decisions there's no appeal, that time comes after sentence is imposed and this court finally rises. And the Constitution does not expressly, we say, cater for Mr Zuma's situation because cases of conviction for contempt of the apex court are so exceedingly rare. But just because that has happened and forced this court's hand doesn't give Mr Zuma a free pass. In such cases, it's this court, which has done its duty to ensure the finality of that section, of that sentence. That is also confirmed by a harmonious interpretation of the Constitution's provisions. That section doesn't sit alone. It must be interpreted in harmony with the constitutional provisions that permit, and importantly, in egregious cases, oblige this court to convict and sentence a person as a court of first and final instance. The electoral court's approach does the exact opposite. It creates disharmony in three ways. Firstly, the Constitution provides that this is the highest court of the Republic. It has original jurisdiction to hear matters as a court of first and last instance. The Constitution permits direct appeals and access to this court as a first instance court and a last instance provider of justice. That is what Section 167(6)(a) of the Constitution, read with Rule 18 of the rules, says. And that says, through Item 16(6)(a) of Schedule 6 to the Constitution, it says the following in the Constitutional's words: all courts, including their structure, composition, functioning, and jurisdiction, must be rationalized with a view to establishing a judicial system suited to the requirements of the Constitution. That's what the Constitution says. And the act that was passed to effect that is the Superior Courts Act. That act does not provide an appeal against the final orders of this court. That legislation, to speak about the legislature, those drafters knew that there is no appeal from the final orders of this court. That legislation has not been challenged as unconstitutional by Mr Zuma or anyone else. The second disharmony is that Justice Zondi's interpretation doesn't come to grips with what this court already held in Zuma 2. This court explained that the denial of the right of appeal to Mr Zuma was permitted by the Constitution. It empowers this court to entertain matters by way of direct access. Said this court, it's the Constitution itself that has in its wisdom seen fit to take away the right of appeal where direct access is warranted. In these types of cases, said this court emphatically, and I quote again, the right of appeal simply does not arise. There's a third disharmony with the electoral court's approach. It fails to take seriously Section 173 of the Constitution and 165. In response to contempt of its own orders, this court protects its process by its inherent powers under Section 173. And by upholding, obviously, the essential provisions for contempt of court in order to protect the integrity of this court's orders under Section 165. And it's said in this regard that there may be instances of contumacy or the interests of justice, which meant that, and I'm quoting this court again, when the constitutional safeguards for the judiciary are undermined so egregiously, Section 173 empowers this court to respond swiftly and effectively in its own interests and in the interests of justice. So that is where, in the debate with, I think it was Justice Turon and one of my learned friends, that's where the Constitutional Court gets its penal powers as an original power. It does so through its own inherent jurisdiction to protect itself and the public that it serves. So an interpretation of Section 47, which excludes the sentence imposed by this court, we say sits discordantly with the powers of this court under Section 173 and 165 and its powers on direct access. And it's not just a discordance. We say it's a grating discordance because it does so by gifting an immunity to a serious violator of the Constitution whose violations may be so egregious that they justified the highest court acting within its constitutional mandate to protect the judiciary and the Constitution from persons who violate its orders. And there is a way, plainly, to harmonize these provisions. It's if a conviction and sentence are imposed by this court, then that conviction and sentence are final and the disqualification operates immediately. Finally, absurdity. We say the electoral court's interpretation is constitutionally unattractive because it leads to three absurd results. The first is the one that's already been highlighted by my learned friends, and that is that this court's orders, the highest court in the land, would fork no lightning for Section 47's disqualification, but the magistrate's court's orders would. Secondly, a person sentenced by this court for a very serious crime and who poses a grave risk to the Constitution would remain eligible to contest elections. But a person that is sentenced by a lower court for a far less serious crime would be disqualified. And third, ironically and arbitrarily, a unique benefit would be gifted to persons who denigrate this court and whose exceptional conduct demanded this court's exceptional response. Yet they are now somehow exceptionally immunized from being disqualified from standing for and holding office. We say that leads to an absurdity which is also a perversity. It runs the risk of a perversion of the Constitution as demonstrated by the facts of this case. It would perversely mean that this court's orders for willful contempt are rendered an empty lightning bolt. But this court said the following when it found Mr Zuma guilty of contempt and orders imprisonment, and I quote again, "He's no ordinary litigant. If his conduct is met with impunity, he will do significant damage to the rule of law." And we say, in closing, in those circumstances, that, Justice Bilkins, again, what is it that that provision is trying to protect? It's trying to protect the rule of law. Because if that type of person is not disqualified under Section 47, it would do significant damage to the rule of law. Thank you, Justices.
Do you have questions for him?
Mr. Du Plessis, on the assumption that I agree with you, that it's possible that the interpretation by the Electoral Court leads to the absurd results that you've pointed out. And on the assumption that the lawmakers did not envisage the Constitutional Court sitting as a court of first and last instance in terms of conviction and sentence. And further on the assumption that the second respondent's conviction and sentence in this matter falls within the substantive disqualification. What do we do with that matter? If we assume that Section 47 was enacted by the drafters having in mind that every person convicted and sentenced has a right of appeal. Now, the plain text of the language in relation to the proviso and when it kicks in, I think that is clear. It kicks in, well, like you say, when an appeal has been heard or when the time for an appeal expires. Now, let's assume the legislature did not cater for this scenario. What are we to do with the proviso? How are we to find a just result in the matter?
Justice Turan, we think the answer was given by Mr. Ferreira, I think. And that is that the proviso doesn't draw distinctions. The proviso speaks about, and really a focus of finality. It's when is something final. That qualifies when the disqualification will happen.
Listen, I'm sorry to interrupt you. I'm asking you to assume that the legislature had in mind when it drafted Section 47 that every conviction and sentence would be subject to an appeal. That the legislature did not envisage the situation where this court would sit as a court of first and final instance. And I see the point you make that what the result of the Electoral Court's decision is. So the Electoral Court's decision, it has the effect of not placing the second respondent under the disqualification almost permanently.
And the answer, we think, is that it's one of those canons of interpretation. You've got to avoid an absurdity. I've given you what we say are the three absurdities. And so therefore you have to read Section 47 to avoid that absurdity. You also have to read Section 47 harmoniously with the rest of the Constitution. And so the drafters of the Constitution and the drafters of the Constitution, of course, we don't know what was in their minds. I take the point Justice Bilkins was saying. We're talking about objectively trying to ascertain the purpose. They are presumed to know the interlacing mechanisms within which the courts work. And they are presumed to know that one of those centrally important features alongside Section 173 is this court's ability to act as a court of first and final instance in exceptional cases, including through 173, to protect its own processes. Now, the moment that's clear, if you agree with that, to use the word assumption, Justice Turan, then the next assumption or conclusion has to follow, which is that if that court finds that its orders are being egregiously disrespected, it must be able to convict and sentence somebody for that as a court of first and final instance.
Thank you, Deputy Chief Justice.
Thank you, Mr. Du Plessis.
I only have one question to ask Deputy CJ myself. Would I please be excused? I think I'm the only council that has to travel back to Durban. I will leave my 2 juniors in attendance, but I think I may miss my plane if I don't.
No, that's perfectly all right.
Thank you very much.
I need your services. Thank you.
Thank you.
Yes, Mr. Mpofu.
Thank you very much, Honorable Deputy Chief Justice. You know, I'm tempted to dive into this interesting and strained interpretation of Section 47(1)(e). But thanks to Justice Mhlanhla's question, it would be important to start with at least one of the preliminary points. And the specific one that I want to hone into is the issue of ripeness. Because Justice Mhlanhla correctly pointed out that the ripeness point is really based on the fact that this matter is not ripe because it should be dealt with by the National Assembly. So in a way, it's a variation of the so-called ultra-virus point. And it's very important, Justices, for us to understand what is this matter before us. I listened carefully to all my learned friends, and only in response to a question from Justice Machit was the word Section 30 mentioned. The whole day we were listening about Section 47(1)(e). But this case is about Section 31(a) of the Electoral Act. That's what it's about. It's not about all these interesting things that have been discussed here. If you go to page 246, I'm sorry, I didn't demarcate the volumes. I'll rely on my juniors. Page 246. It's very clear that the decision that the MK Party and Mr. Zuma were appealing in the Electoral Court, which they successfully appealed so that we got here, was a decision taken in terms of Section 31(a). It says so in black and white. It's a letterhead of the IEC, objection to list of candidates in terms of Section 30 of the Electoral Act, and so on and so on. Unfortunately, the section is quoted in full there. Now, here's the thing. We say that we make the plain and well-known statement that for an organ of state or an institution such as the IEC to act to disqualify somebody or do anything adverse to their interest, it's the first rule of the rule of law, from Fairshore, from pharmaceutical, from all those cases, that that institution must have a legal basis for doing so. Now, the legal basis that has been invoked in this case is Section 31(a) of the Electoral Act, not Section 47. They simply say in their exercise of Section 31(a), they then do all these things about Section 47. Section 47 is not why we're here. Now, what does that say? It says that the primary question that this court has to answer is whether the IEC has any business in disqualifying Mr. Zuma for the membership of the National Assembly. If it doesn't, that's the end of the case. And I ask this question rhetorically, where is that power? Where does the IEC get the power to implement Section 47 for disqualifying someone in the National Assembly? The answer is nowhere. The fallacy is born out of the following myopic reasoning. That section is quoted at Section 30 here. It says, any person, including the Chief Electoral Officer, may object to the nomination of a candidate on the following grounds: that the candidate is not qualified to stand in the election. That's all. Now, let's go to Section 19(3)(b) of the Constitution to see where the fallacy really comes from. Section 19(3)(b), unfortunately, I suppose the drafters were trying to save space and time. So people read it as if it talks about one right. It does not. That Section 19(3)(b) talks about two distinct rights, joined by the word "and." The word "and" in the dictionary meaning means you have two things. It's me and my learned friend. So what are those two things? It's the right to stand for public office. Let's pause there. That is exactly what is said in Section 31A. The candidate is not qualified to stand in the election. So that section is about that right. And then it goes and says, and. Then it deals with a completely different right. The right to hold office if elected. That one is a qualified right. If elected, you have the right to hold office. And that's where the entire misunderstanding comes from. Because they seek to expand the powers of the IEC, which have been circumscribed to the first right defined in 1903, to go to the second right. So let me put it like this in shorthand. The power to stand in an election is in the full province of the IEC. It's clear from Section 31A. But the power to qualify or disqualify someone, if elected, to hold office, has got absolutely nothing to do with the IEC. Absolutely. That secondary power, which only arises if you are elected, is in the province of the National Assembly. And that is for simple reasons. If the drafters of Section 31A wanted to include both legs of 19(3)(b), they would have done so. They would have said, any person may object to the nomination of a candidate on the following grounds: the candidate is not qualified to stand in the election, and if elected, to hold office. They deliberately truncated the right and demarcated the right in 19(3)(b) into its constituent parts and only concerned themselves with the first part of that right. There's nothing which would have stopped them to just reproduce 19(3)(b) if that was the intention. So really, we're just swimming in the wrong pond, because if we accept, and remember the powers of the IEC are circumscribed in section 190 of the Constitution. So the IEC cannot have powers beyond section 190. What does section 190 say? It says, and I'm paraphrasing, in 191 it basically says those powers will end when the results are announced. If there's ABC, and the third one is the announcement of the result. So that's it. The power of the IEC is, after that, it's functus officio. And that's, let me explain, qualify that, because I found a point against myself on that issue. There is a section 114, I think, of the Electoral Act, which then goes to the appendix. And it says that the IEC may allocate seats, right? Not members, seats. And that is also true.
114, sorry, Mr. Mpuhu.
114, yes. Okay. And adjunct to that is an appendix, I think it's appendix 3. The effect of it is that it gives the IEC power of allocation of seats, and we know what that means, all of us in South Africa. It means once the election is over, they'll do the mathematics and then say party A has got 100 seats, party B has got 200 seats, and so on. So we concede that in terms of 192, because 192 talks about additional powers, that is one of the additional powers of the IEC. But beyond that point of the allocation of seats, the IEC is totally functus. And that wording is used advisedly, the allocation of seats, not the allocation of members. So they say you have 20, you have 30, who you put there is your business. And whether those people that you put there are qualified in terms of 47(1)(e) is the business of the National Assembly. It's very simple. So the IEC cannot exercise a power that it does not have to administer the second part of section 19(3)(b), where it has no power, it has no source for that power. It doesn't work like that. The whole thing called the rule of law means exactly that. You must be able to point us to the source of the power. So let's put that aside. Because that point goes to ripeness, as Justice Nhlanhla alluded to. Because if we are correct that this business is a business of the National Assembly at the first sitting of itself, which is in terms of the rules and in terms of the Constitution itself. You'll find that at section 52 of the Constitution, 52(1), it says, at the first sitting after its election, or when necessary to fill a vacancy, the National Assembly must elect a speaker, a deputy speaker among its members. Now we know that in terms of Rule 13, which is quoted, I'll find the section. In terms of Rule 13 of the Rules of the National Assembly, firstly, before we go to Rule 13, we have to go to section 57. 57 of the Constitution says the National Assembly may determine and control its internal arrangements, proceedings, and procedures, and make rules and orders concerning its business. And we're saying that this is its business, with due regard to representative and particular democracy and so on. So the real separation of powers issue is this one, not the imaginary one that we have been told here. It is whether an institution of democracy, such as the IEC, public protector, or what have you, can ever have the power to intrude into the exclusive domain of the National Assembly when it has no authority to do so. Quite frankly, even if it had authority to do so, it should be stopped. But when it has no authority to do so, how can it intrude into the exclusive powers of the National Assembly? It can't. Now, then I come to this point, the Rule 13. Rule 13 says, a At its first sitting, the National Assembly must do three things. 1, swear in the members. 2, elect a speaker and deputy speaker. 3, elect the president. That sequence is not coincidental. The reason there is another, what you call, permitted intrusion into the exclusive domain of the National Assembly by the fact that the Chief Justice is asked to chair that meeting is because at that point, nobody qualifies to do anything. You can't say, I'm going to be the speaker, therefore I'm going to chair this meeting. So the Constitution had to find a creative way to say that meeting must be chaired by the Chief Justice of the country, and then the following three things happen. Swearing in of the members. It is at that point in that meeting that if there's an objection to a particular member, that member would be, eligibility would be debated. Once the members have been sworn in, they then nominate someone to be the speaker. Once the speaker has been nominated, the speaker assumes his or her office and then presides over the election of the president. So it's a clear, swift process, which is logical. So you can't start with the president or start with the speaker, because who's going to nominate the speaker, because there are no members. So the members have to be sworn in first. It is at that point, to come to Justice Nhlanhle's point, that the matter becomes ripe. This is crucial. So unless anybody is going to tell us where the power of the National Assembly to intrude into that space comes from, then that, with respect, should have been the end of the matter. So let's park that. Because that point is a point in any event, even if you were to find against us on the merits of the appeal, it's a point that's also raised in the so-called conditional cross-appeal, because it's dispositive of the whole case. And that's why I'm raising it up front. Then there are the other, quickly let me go through the other preliminary points. The issue of urgency and bypassing the SCA and direct appeal is crucial for many reasons, but the direct appeal, let's park that because it's important for the issues that were raised by Justice Taron as well. You cannot come to this court and say that this is urgent, it must be heard before the 29th of May. Why? Because the citizens want to know who's on the list. I mean, what is that? The citizens, there are 15,000 of those candidates. Maybe as an aside, I should say that I'm one of them. But the fact that I or someone else is on the list, does it mean anything? The citizens, was on the list in 2014, 2019, and so on. The citizens will have to wait until after the election. Each of those 15,000 people decides whether they want to go to Parliament. And if they do, whether they want to go to the National Assembly. So the matter does not arise until that point. So that now this is a phantom crisis of the citizens who want to know all these 15,000 people. Secondly, if you are correct that the matter only arises on the 14th, I think it says 14 days, so I'm just using arbitrarily, 14th of June. So the first meeting must be after 14 days. Then the matter is not right for that reason as well. So let's come then to the issue of direct access or direct appeal. Well, the direct appeal can only be given in those circumstances where these things have been pleaded and satisfactorily so. Why are you bypassing the SCA? Why are you coming here urgently? And thirdly, it's not correct what Mr. Ngqaitobi is saying, that the issue of prospects of success only, if you don't like the prospects of success, you must just dismiss it on the merits. No, it doesn't work like that. Prospects of success are in Rule 19 as one of the criteria for granting the leave to appeal in the first place. So once you put that to bed, that's the end of it. But let's then come to the celebrated Section 47 issue. The Section 47(1)(e) issue is a red herring. Even assuming the IEC had any jurisdiction over determining who's a member. And by the way, I'm sorry, a section we say should be read as a whole. So look at 47(2). 47(2) makes it clear that there's a difference between standing in an election and holding office. It says, a person who is not eligible to be a member of the National Assembly in terms of Section 1A or B may be a candidate for the Assembly subject to any limits or conditions established by national legislation. Now, what does that tell us? It tells us that the Constitution knows the difference between eligibility for membership of the National Assembly and standing for an election. So when it puts only one part of that in Section 31A, it knew what it was doing. But go further, 47(3). A person loses membership of the National Assembly if that person ceases to be eligible. That's the point. If you get sentenced to 100 years or whatever, on the 4th year of the parliament sitting, then you cease to be a member once you become ineligible, either because you are of unsound mind or some would say that that is an underused criterion. But if you become of unsound mind or you are an insolvent and so on. So again, 47(2) and 3 make it clear that this is the business of the National Assembly. Because the absurdity would be that, just imagine this, if you became an insolvent on the 3rd year, then according to Mr. Ngqaitobi's interpretation, you must then go to the IEC. And do what? The IEC will say, get out of here. It's not our business, it's the business of the National Assembly. So that Section 47 makes that point very clear. So let's now deal with the interpretation of 47(1)(e). Justice Theron is perfectly correct. We have to assume that the drafters of the Constitution knew, when they used the word convicted, they didn't just invent it in Section 47. That word is used in Section 35 for the first time. Convicted. There is a presumption of interpretation that a word used in the same constitution or in the same statute has the same meaning. So that's why they didn't say all these things that are now being smuggled in. Well, if the appeal is available and so on. No. They say if you're convicted or sentenced, if you want to know what convicted means, go to Section 35. And Section 35 makes it perfectly clear under what circumstances a person may be convicted, or sentenced for that matter. And those circumstances are that you would have enjoyed all your rights in Section 35(3). So it's not rocket science. That's how it works. Every first-year constitutional law student knows one thing, called Section 39(2) of the Constitution. And that section says the Bill of Rights is your starting point. So this idea that you can start in Section 47 and forget about Section 35 is repugnant to everything we know about the Constitution. Because Section 35 is part of the Bill of Rights. It's hierarchically superior to Section 47. That's plain. So even if you had to do the so-called harmonization exercise, your starting point would have to be the Bill of Rights. You have to start with Section 35 and you have to start with Section 19. Those provisions of the Bill of Rights will guide everything you do after that. You can't start, it's like this notion that you can deny somebody the right to appeal because Section 167 says you may, which it doesn't say so, by the way, but we'll come to that. It's repugnant. How could you deny someone the right to appeal in 35(3)(0), which is entrenched in the Bill of Rights, because there's some procedural thing about direct access? You can't. That's turning the Constitution upside down. Same thing with Section 147. My learned friends, all of them, I listen very carefully when they talk about the cases that interpret a proviso. They correctly say it's a deeming proviso. That's true. But then they say the deeming proviso must be interpreted by looking at the governing section. That's also true. But the problem is that they contradict themselves. One, they say that a deeming proviso says that what is not, which is also true. So the deeming proviso says that what might look like a sentence at face value is not for the purposes of this section. That's why it says but, and so on and so on. But the biggest fatal mistake they make is not to recognize the structure of Section 47(1)(3). So, my learned friend, Mr. Ngqaitobi, has got an impossible task. Because firstly, he must discharge the onus as an appellant that the Electoral Court was wrong. Secondly, he must overcome the other onus which comes from exceptional circumstances. We know that when there are exceptional circumstances, the person who asserts those exceptional circumstances must prove them. And then he must then go to the proviso, which says but, this and that. So all those are three hurdles which are, with the greatest respect, impossible to pass. Because my learned friends say the governing section of the section is that part that says anyone after a section took effect is convicted of an offense. No. The governing section of 47(1) is at the beginning of 47(1). It says every citizen who is qualified to vote for the National Assembly is eligible to be a member of the Assembly. That's the governing section. That is a restatement, literally, of Section 19. Which means you are being told, anyone who interprets this, do not pass begin. You must start at Section 19. That's why the drafters saw it fit to put that governing section. That's what was said in the Freedom Plus matter. That's what was said in all cases that we know of. That's what was said by Justice Madlanga in New Nation. At paragraph 99 of New Nation Movement, NPC versus President of the RSA, Justice Matlanga said the following. He was being asked there to do this impossible exercise of comparing a provision of the Bill of Rights with one of the general provisions. And he said, viewed with this background in mind, Section 157(2)A, which was that provision, does not contradict Section 19(3)B. In that context, Section 19, which is the primary source of people's political rights, continues to be the fundamental norm on them, not Section 157(2)A, which is tailor-made for municipal elections. The normative force of Section 19 continues to apply in every instance where the Constitution has not specified a system of representation different to what Section 19 requires. How do you transpose that into this matter? The normative form of Section 19 applies in every instance where, as I've said earlier, there is nothing, you can't even put scales, because if you weigh something against nothing, it will be that thing. So if there is nothing that empowers the IEC to do what it did, then we're even in a worse off position than what Justice Matlanga was dealing with. I'm sorry, I'm looking for the quotation in, yes, Freedom Front. You'll find that at page 14 of our heads to the conviction point. The same thing that Justice Matlanga was saying was expressed by the Electoral Court. It said, quote, we need to remind ourselves that what we are concerned with is a citizen's right to stand for public office, which was the issue in that case. Not the other right, but we know that they are conjoined. Which right is enshrined in Section 19(3)B of the Bill of Rights. It cannot be limited, save as justified in Section 36 of the Constitution. It is therefore against the backdrop of these imperatives that Section 47(1)E must be interpreted and applied. It has to be interpreted, I think, in a way that must promote the values that underlie an open and democratic society based on human dignity, equality, and freedom, and gives effect to the right to stand for and, if elected, to hold public office. It cannot be clearer than that. We know from the Hande case, line of cases, that that's what this court has held should happen even in the so-called harmonization process. Assuming for a minute there was a conflict between 47(1)E and Section 19, or even Section 35, then it has to be resolved in favor of those fundamental rights. So that, I'll come to Justice Matopa's point. Let me try and deal with this systematically. So where does that leave us? It leaves us with the three issues. And I'm surprised Mr. Ngokaitobi says there are 2 issues on appeal. Because there are clearly 3 issues. When this court has specifically asked us to make special heads of argument on the conviction point, you can't say there are 2 points. The third point is the conviction point, and correctly so. Because it's an absurdity to separate the sentence from the conviction when it comes to the question whether Section 47(1)E, whether those terms are what it was contemplated in 47(1)E. And put terminology aside, Justice Matopa was indirectly criticized for using intention of the legislature. But it doesn't really matter. The point is, when the Electoral Court says, is that within the contemplation of Section 47(1)(3). They exactly mean that. In other words, did the drafters contemplate that they will now be dealing with a conviction, which is not the conviction that they have prescribed in Section 35? Surely that's just myopic logic. How could the drafters have expected or contemplated that now all of a sudden there's a new species of conviction now in section 47(1)(e), which is totally repugnant to section 35. When Justice Khampepe, and that's why we say we are not fighting with that judgment. Justice Khampepe, in many passages, says that, I think it's paragraph 76 or 80. She says, this is not a conventional criminal trial. In so many words. And she says, as was pointed out by Justice Theron, she says, we're dealing with a situation where there is a denial, no less than that, a denial of the right to appeal. And then she says at, paragraph 76, which answers the question, Deputy Chief Justice, that you posed in the directions. It's here. She says, ordinary criminal proceedings differ vastly from civil contempt proceedings. I'm reading at page 43 of the papers and 76. And it cannot be that something as simple as a party's, in this case the appellant's pleadings, can have the effect of marrying these two markedly distinct concepts. So the majority says these two concepts are markedly distinct. So that's the answer, that the civil proceedings and the ordinary criminal trials are markedly distinct things. Now, if we accept that, then the Deputy Chief Justice's question or the court's question becomes relevant. If we accept that there are two distinct, then the only question that remains is, does section 47(1)(e) apply to both types? And the answer must be a resounding no, because section 47(1)(e) surely applies to type 1, let's call it that, which is the criminal proceedings as we all know them, because that's what it says in section 35. Apart from that, apart from the frank concessions, with respect, the frank admissions that these rights are being infringed or limited or denied, whichever word you choose, there is the following problem that my learned friends have. And it also arises from one of the questions. Where does the court derive the penal power to, sitting as a first instance, impose a criminal sanction? And that's why it has not been understood why we make this concession readily. Mr. Ngugatopi spent time trying to tell us that contempt is a criminal offense. We don't quibble with that. We made that concession in the earlier court, but it serves this purpose. If it is a criminal offense indeed, then is the conviction a conviction? That's the secondary question which was raised in the directions. And the answer must be no for the following reasons. Assume it's a criminal offense for present purposes. But it's a misnomer to call it a conviction. Actually, it's just, this thing is not even a conviction, it's a committal. It's a committal order, unsuspended committal order for contempt of court. That's the correct categorization, legal categorization. It's not a conviction, because a conviction we know is defined in section 35(3). And if it is a committal, unsuspended, on an urgent basis, by the court sitting as a first instance, in motion proceedings, everything you can think of, could it conceivably be what the drafters contemplated? which drafters would have contemplated that one day, despite what we have said in Section 35, there'll be a criminal conviction, which is a result of urgent proceeding in motion court by direct access, denying all, and I'm saying that deliberately, all the 15 rights listed in Section 35(3), all of them. Not only were those rights denied, but they were even used as punishment. Mr. Zuma, one of the so-called aggravating reasons why he had to go to jail directly and so on, was because he exercised his right to remain silent. Something that benefits all other persons who have criminal conviction. But this court said, because he refused to respond, for example, when we said we want mitigating circumstances or whatever, that denial of the Section 35(3) right is actually the very reason why he must go to jail. We can't have this. We can't, you know, the taking away of the freedom of a person without a trial is not something that can be brushed aside by, you know, terminological tricks. It has to be said that these framers of the Constitution contemplated such a thing. On what basis? Then we move to, so we say that the conviction firstly is a misnomer, it doesn't apply, and it's not a conviction as defined. But then let's go to sentence. Sentence suffers from the same problem, because as we all know, the sentence comes from the conviction. So that's why the two things are not separable, as my learned friend Mr. Ngwatobo would like us to have. And by the way, just for the sake of, yes, thank you. Okay, no, let me, I'm sorry, Justices, something has just been brought to my attention, which is so that we round off the conviction point. One of the points we make is that the court in Faki, at paragraph 27, posed a very important question and said that counsel had raised the issue as to whether a conviction for civil contempt would constitute previous convictions. This is important. Remember, forget previous. That's just an adjective. But the question that was posed there was, is a conviction for civil contempt a conviction to such an extent that it would constitute a previous conviction? Yes, I've got it. Yeah. And this is what Justice Cameron said at paragraph 20. Okay, let me paraphrase to save time. He effectively says, I'm leaving that question open. Says that question will be answered in another matter as to whether this conviction, which looks like it at face value in front of all of us, is a conviction in real terms. Now we make 2 points about that. One, it is that if the answer to that question was as obvious as Mr. Ngwatobo would like us to have it, then Justice Cameron would not have left it open. It is because it's not an easy question whether this is a conviction or not. And that's the reason that he left it open. The second question is, second issue is that we say the electoral court then, and then we also give them a defense, maybe because the matter was urgent and so on, lost a golden opportunity to answer that question, which Justice Cameron had posed. By the way, if anyone listens to the transcript of those proceedings, the very first thing Zondi JA asked me as I stood up, but Mr. Mpofu, is this a previous conviction and will it appear in this SAP 69? That's the exact question that is in paragraph 27 of FAKI. It even talks about the SAP 69. The second issue is that this is not just something where we're clutching at straws just to, because it's convenient to do so, because we received a direction from the DCJ. No, this was pleaded. It's pleaded by us. If you go to page 262, at paragraph 24 of the Notice of Appeal, the very first document that was ever served in this matter, Notice of Appeal, we say the following. A declarator, such as the one issued by the court, that's the Constitutional Court, cannot amount to a conviction, a previous conviction, or a criminal record as intended in the section. Now that should close it, because we say that it might look like a conviction to the naked eye, but in terms of the law, it is not a previous conviction. So we were provoking the question that was raised in FAKI. Now, so it's not a conviction, it's not a previous conviction, or at the very least, there's no answer to, at best, there's no answer to that question. But that mere fact that question it might be hanging in the air. Imagine if someone was convicted in the magistrate court or in the high court, and then you came and say, is it a conviction? Everyone would say, what are you talking about? It's obviously a conviction. Will it feature in the previous conviction? Of course. Will it be in the SAP 69? Of course. But this so-called conviction for in a civil court and in motion court and so on cannot be. The next point comes to the mischaracterization of section 167 and 172 of the Constitution. Imagine if you could wake up some of the drafters of the Constitution and you say to them, when you drafted 172, 1A, giving you the power to give declarators, in that you included the power to impose criminal sentences as a court of first instance. They would say, sorry, that's not 172. How could you, under 172, 1A, impose a criminal sanction? And that is why you must read 172, 1A. And remember, in paragraph 86 of the Hambembe ADCJ judgment, 86, she says, explaining where the power to grant that sentence, she said, by this point, it needs no repeating that the only rationale provided to this court for the granting of a punitive sanction was that put forward by the applicant. However, it is trite that this court enjoys a wide discretionary powers and that we are enjoined by the Constitution to grant appropriate remedies that are just and equitable. In these circumstances, and for the reason that follow, I'm certified that an order of unsuspended committal is just and equitable. And the footnote is footnote 101. Look what it says. Section 172, 1B of the Constitution empowers this court to make any order that is just and equitable. Well, I'm prepared to say that, to lay my life on this one, that no drafter of the Constitution would have contemplated that 172, 1A or B for that matter, empowers this court to give a criminal sanction as a court of first instance in motion proceedings, in urgent proceedings. Never. So the very exercise, that then goes again to the question of the conviction. This is a conviction in terms of 172, 1B by the admission of the majority. Goes back to the original question. Could it have been that the drafters of the 47(1)(e), when they were drafting that, contemplated that there will be a conviction and a sentence issued in terms of 172(1)(b? No. Surely. The next one is section 167, which is also being abused. Section 167 says that the 167(6), national legislation or the rules of the Constitutional Court must allow a person, when it is in the interest of justice and with the leave of the Constitutional Court, A, to bring a matter directly to the Constitutional Court, B, to appeal directly to the Constitutional Court from any other court. So that's the point. So this court was clearly not exercising, because it said it's denying the right of appeal. So it was clearly not exercising the power under section 167(6)(b), but it was exercising the power under 167(6)(a) to bring a matter directly to the Constitutional Court. How could it be that by giving that procedural right, the drafters of the Constitution wanted to take away the fundamental human rights in Section 35? How could it ever be? How could it be? Because this is a procedural convenience, which A, does not contemplate criminal proceedings, but B, certainly does not contemplate itself defeating the Bill of Rights. It can be. So it's not a conviction for that. Thank you. For that reason as well. Sentence. Now, the sentence, we say we use 35(3)(0) as a proxy. Whenever I talk about 35(3)(0), you must know that I'm talking about all those rights, because all of them were denied in Section 35(3). But Section 35(3)(0) brings the matter home easily. Why? Because Section 35(3)(0) says you have a right to an appeal. In other words, that right we know attaches to both the sentence and the conviction. And that right must be exercised. Everything I said earlier about conviction applies to it. But that's not the question, of course. The question, we must always come back to the question in this case. When the framers of the Constitution did 47(1)(e), did they contemplate a sentence such that it breaches, limits, denies 35(3)(0) rights? And the answer to that must be a resounding no. And that's what Justice Zondi was saying, that this could not have been in the contemplation of the drafters, that there would one day be what Justice Khampepe called an unprecedented and unimitable situation. You know what that means? That means it has never happened and is unlikely to ever happen again. So it was a particular situation influenced by the fact that Mr. Zuma was a head of state and so on. And there's a whole thing about, there's a whole section on that. So that is why it is in that respect that we say, this is what, if you look at it crudely, this was nothing but reminiscent of the so-called Sobukwe clause under apartheid. And whether one agrees or doesn't agree with that categorization, the point is only this. Could the framers have contemplated that when they wrote those words, convicted and sentenced in 47(1)(e), it would include some unprecedented, in fact, I'm putting it in milder terms. Sorry. I think it's paragraph 56. No, 56. 36, at page 32, yes. She said, however, I'm alive to the fact that the case before us is so markedly distinct from any matter that has preceded it, that it exceeds the expectations of legal precedent. The result is that, despite my efforts, I have found very little solace in our jurisprudence. In other words, there's nothing like it. The extent and gravity of the contempt in this matter is singularly unprecedented and absolutely inimitable. So I left out those adjectives. Singularly unprecedented and absolutely inimitable. Who can say that the drafters of the Constitution contemplated such a thing? Now, so the sentence is even in a worse position than the conviction, save for the fact that the sentence is in any event a surrogate of the conviction. And that's why we say we really welcomed, without needing to patronize the court, we welcomed the directions from the Deputy Chief Justice on this question of conviction. Because with the greatest respect, it was absurd to say the sentence is not within 47(1)(e), but the conviction is. The section is very clear that those two things go together. 47(1)(e) says, anyone in this section is convicted of an offense and sentenced to more than 12 months imprisonment. And even in the appeal proviso, it says, but no one may be regarded as having been sentenced until an appeal against the conviction or sentence has been determined. So it's clear that the two things go together. It would be absurd for any court to hold that the sentence was not a sentence because of Section 35, but the conviction was a conviction. So we welcomed the directions in that sense. But let me just say the following quickly about the right of appeal. And you'll find this at pages of in our submissions on conviction. Yes. From page 8, from paragraph 25. This court said, well, in Tuli, it says the minimum that it says 3530, the minimum that it envisages and implies is the opportunity for an adequate reappraisal of every case and an informed decision on it. One of the justices, I can't remember, I think it was Justice Matopo, asked this question as to whether the Section 3530, they said the minimum, the bare minimum it envisaged is a chance for a reappraisal. And then in Stein, the following was said, the right is directed at ensuring that there is a reasonable procedure for correcting errors, coming back to Justice Majid's earlier point this morning, for correcting errors that may have occurred at the trial stage. In a substantial number of criminal cases, convictions result in prison sentences. During its term, imprisonment brings the liberty of the individual to a halt. It also impacts on the individual's dignity. Therefore, it cannot be overemphasized that before this happens, there must be procedural checks and balances of such a nature that wrong convictions and inappropriate sentences are reduced to the barest minimum. An appropriate reassessment mechanism is an important cog in this scheme. I think it was Justice Matlanga who said that. And then in Stein, it was also said that 25(3)(h), which is the equivalent of the current 35, that every accused shall have the right to a fair trial and so on. So this court has specifically said on many occasions that the right in 35(3)(o) is an inherent feature of a sentence. It's not some by-the-way thing. It inheres in the thing called a sentence. So a sentence that is bereft of that right is not a sentence, cannot be a sentence for the purposes of Section 47(1)(e). Even if you were allowed to do the so-called harmonization exercise that is completely disallowed. Now, so that's the first part of whether the sentence is a sentence for the purposes of 47(1)(3). Then the last point on the merits is the remission point. Now here, you get literally, gymnastics of the first order. They say that they accept, grudgingly I must say, because they didn't accept this for a long time in the electoral court. But they now say, because there's no other way, quite frankly, they accept that Mr. Zuma's sentence was completed on the 11th of August, 2023. Now, if you read that together with the order of the SCA that we discussed earlier, which said he must return to escort for the purposes of serving the remainder. What was that remainder? The 9 months. So, but for the remission, he would have served the 9 months. I don't know if he would be out now. Maybe not. But you can't wish away the remission, because but for the remission, he would have served the 9 months. And that 9 months, justices, is what is the extent to which the sentence was reduced. Smith says so, Busheko says so, all the cases say so. They say that the effect of remission is the reduction of the sentence. And I don't want to disappoint Justice Matopo, but I'm not in a biblical mood today. So forget about the biblical definition of the remission of sins, which, by the way, is the only reason we all go to church on Sunday. If you thought you could go to church and then when you go there, they say, no, but remember 10 years ago, but you said, but that sin was remitted. They said, no. Mr. Ngopaitobi says no. So you must go to hell, literally. No. So let's forget about that for a minute and look at the definitions that are more conventional. Sorry. The definition in, I had this. The definition in the Oxford dictionary, law dictionary, says that remission is the cancellation of a part of the sentence. It's that simple. Can I find it in our hands? It's the cancellation of a part of the sentence. Funny enough, the definition that you also find in the Oxford Thesaurus says the following, among other things, that remission amounts to setting aside, lessening, reducing the sentence. Now, if that is so, and those definitions accord with just for Oxford, page, what paragraph? 73. Okay, thank you. I'm sorry, Justices.
We're on extra time that you're not even granted.
Yes, I'm aware.
We don't want to be accused of being unfair by the others who had to abide the clock.
I'm sorry, Justice. I was taking my I know that this is defined in our heads, but the point is that there's also section 82. Let's forget about the Bible for now. Section 82. 1B of the Correctional Services Act is almost a mirror image of that Oxford dictionary.
148.
Okay, thanks. I'm told these are in paragraph 148 of our heads. Yes, at page 50. So the Oxford Dictionary Law defines remission as cancellation of part of a prison sentence. Oxford Paperback Thesaurus defines remission to include cancellation, setting aside, which is very important, lessening, decrease, reduction. And I say that the section 82, 1B of the Correctional Services Act says the president may remit part of a prisoner's sentence. So that tells you exactly that it's almost a mirror image of the Oxford Dictionary. So that makes it clearer that in the eyes of our law, remission means remitting a part of the sentence. It's a discount, for lack of a better word. So you can't say, I've been given a discount, but I've bought in the original price in the same breath. And that takes us to Justice Matopo's question, which, by the way, should dispose of this entire matter. Justice Matopo asked Mr. Ngqaitobi, do you accept that if this was a pardon, we wouldn't be here? Mr. Ngqaitobi was forced to admit that. Why is that significant? It's significant when we are talking now about sentence, not forget about the conviction part. Because the difference between remission and pardon is exactly that. Is that in the pardon, in the case of a pardon, both the conviction and the sentence are cancelled, which is why Mr. Ngqaitobi had to make that concession. But in the case of a remission, only the sentence is cancelled. So that's the end of this case. Because if remission means that a portion of the sentence has been cancelled, reduced, call it what you will, then of course Justice Mudiba's interpretation must be correct, which is that the legal effect, to use her words, the legal effect of that reduction, just like the example I was making of a discount. If there's something that's called 100 Rand, but I'm given a discount of 50 Rand, the legal effect of that is that what is left is 50 Rand. So that's really, it is that simple, and that's the distinction. The problem with my learned friends is that they fudge the issue and want to confuse remission with parole. Parole is a completely different thing. If you are released on parole, you are still basically in the same position, except that you may no longer serve that sentence behind the bars. We read Pasha earlier on. But parole does not feature here. This is about remission, and which then takes us very quickly to the issue of separation of powers, which is another mirage. You cannot isolate linguistically remission from pardon, from reprieve. There is a reason why all those things are found in one sentence in section 84.2J. In section 84.2J, which is the so-called prerogative powers, it doesn't make this distinction that is sought to be made even by the amici. It simply says the president has the power of pardoning, reprieving offenders, and remitting any fines and penalties of forfeitures. So those are part of the same genre or class, constitutionally speaking, except that they have different effects, as I've explained earlier. The one might affect the conviction and the sentence. But constitutionally, they are the same thing. Why are they the same thing? The reason why they are put here in that section is because these are extraordinary powers which are given to a president. Extraordinary. I said this in the electoral court. I'm one of those people who have always argued against this so-called prerogative powers, because I think it's just a hang-up from our colonial past. But it's here. And remember where the prerogative comes from. It comes from the British notion, silly notion, that there is God, and then there's the king, and then there's the rest of us, the state. So those people have superpowers. They can do anything. So the prerogative, which is why I don't like it, it brings back those notions. But for better or for worse, we have decided to preserve the prerogative. And that is why the power to remit is located in the prerogative section. It's not located in some section. It's the untouchable, where the president, unless if you're going to say, as we said in Albert, if you're going to say it was not exercised rationally and so on, that's a different matter. Nobody is saying that here. So that power is untouchable. And it is untouchable because of what is said in Sibiya and in Mensing and that line of cases. Because the president...
Please wrap up, Mr. Mpofu.
Yes, I will.
One more minute now.
Yeah. Well, all right. Let me move to another point then. But the point I really wanted to make is that the power to remit sentences and constitutionally reverse that what the judiciary has done is vested in the president. Remember, this court has now determined authoritatively that those powers are suprastatal, if there's such a word. Those are the powers that are exercised by the president as head of state. What does head of state mean? It means the head of state of the legislature, of the judiciary, and of the executive. So the prerogative powers are exercised as the head of state, not as a chairperson of the cabinet. They are above the judiciary, the legislature, and the executive. And if you don't believe that, you must look at section 84.2b, which says the president is responsible for referring a bill back to the National Assembly for reconsideration of the bill's constitutionality. So at face value, the president is now interfering with the legislature. But because that power is located there, he does it all the time. Nobody can say it's a so-called separation of powers. Now, let me then quickly, the one point that we have not addressed, because Mr. Ngubatobi dealt with the conditional cross appeal, and it's late in the day, I might as well, while I'm on my feet, deal with the second part. Ultra-virus I've already dealt with. And the conviction, there are three grounds in the conditional appeal. It's the conviction point, it's ultra-virus, and then it's bias. And I've dealt with the other two, so there's only one point that is left. We say that even if the court is against us on everything I have said, that decision cannot stand because it was tainted by bias on the part of Ms. Love, at best, or the entire commission. Now, this is a very, very, very serious matter. Apart from Justice Pillay that we spoke about, who correctly recused herself, Ms. Love had the following situation. She had pronounced that Mr. Zuma is not eligible, in the words of Section 47(1)(e), is not eligible to stand for office as a candidate or as a member of the National Assembly. For the current purposes, that distinction is not important. You can't do that. Imagine if one of the judges sitting here was asked by some journalist, what do you think of this Zuma case? And say, no, he doesn't have a case. Or he does have a case. That would obviously be a ground for recusal. Why? Because you would have expressed a view on the very question that you are supposed to sit and adjudicate as a neutral person. But here is the thing. We have now discovered that not only Ms. Love, but Mr. Muepa, who's the chairperson of the IEC, have actually perjured themselves. And I'm saying that in so many words. Perjury in the following way. It turns out, you saw, we've put in an article that was on the 17th of January. Remember, the impugned article was on the 24th of January. It turns out that on the 17th of January, the IEC issued what was called an official statement saying Mr. Zuma is not eligible to stand for the for the office. Official. 493. No, that's yes. It says, yeah, it's official. This is the 17th, underlined 17th of January. It's official, former President Jacob Zuma.
Which page of the record is that?
493, this chair. Thank you. It says, it's official. Former President Jacob Zuma cannot be the president of the country after this year's general election, obviously because he can't be a member, because of his criminal record, going to 494. This was clarified by the Independent Electoral Commission in its formal response to the Daily News on Tuesday. The electoral body cited sections 47(1)(e), I suppose, of the country's constitution, which bars anyone who has been convicted of a sentence, and so on and so on. Formal, so there's a decision of the IEC, which was taken on the 17th, whatever the Tuesday was. So all Ms. Love was doing was simply to articulate and confirm a formal decision which had been taken by the IEC that said former President Zuma cannot stand because of the 47(1)(e). That is serious. And yet, this is what they say at page 281, which is false, to put it mildly. Page 281, this is what Mr. Oh, yes. Okay, I'm sorry. I'm told to read the last part of 494, which is correct, yeah. It says, therefore, this is the formal response. Therefore, this provision renders former President J.G. Zuma disqualified to be on the list of any party contesting an election or to contest as an independent in the upcoming 2024 elections. And yet, the same people who made that formal decision and then pretended to be neutral on the same question a couple of months later, say to this court under oath, this is where the charge of perjury will be laid. They say the Electoral Commission was not responsible for the headline of the article reporting the Electoral which is true. The Electoral Commission denies the accuracy of the headline and reporting, but here's what they say. The Electoral Commission did not decide, at least not before its decision that is the subject of these proceedings, that Mr. Zuma is not eligible to register as a candidate for elections, as the headline states. No reasonable observer of the press briefing on 2024 would have reached that conclusion. That is a lie. Because they exactly what they say they did not do is what they did. They had decided a week before on this point. And what makes it worse now is that in the current papers before this court, Ms. Love, for the first time, puts, because we made that criticism in the Electoral Court, that this so-called interpretation is not even backed up by her. So this time she put a a confirmatory affidavit confirming these lies. So on whichever way you look at it, once they had made this decision, in fact, Ms. Love's transgression pales into a smaller transgression, because maybe one can say she talked too much. But that was not the original sin. The original sin was the fact that she was expressing and confirming. And look at 21.2. They say, the Electoral Commission did not confirm, or at least not before its decision that is the subject of these proceedings, that Mr. Zuma does not meet the requirements to register as a candidate to stand in this year's election. As the first and third paragraph of the article state, no reasonable observer of the press briefing 25 would have reached that conclusion. That's another blue lie. Because indeed what Ms. Love was doing was to confirm that position, which is what we said in our notice of appeal, and it was dishonestly denied in these proceedings. So how can anyone who now has the advantage of knowing exactly what preceded that this was basically a second decision. I mean, it's even worse than what we imagined at first. What Ms. Love was pronouncing was a second decision of the commission. In so many words, citing 47.1e, who can say that these people could sit as a neutral arbiters on that very same question which they had decided? So, on the cross appeal, we say, assume everything else is wrong. The decision cannot stand, A, because it was tainted by bias and perjury, but B, because it was in any event ultra-virus the powers of the IEC, which is where we started. But we say, that's why it's called a conditional cross appeal. We say, if you are with us on the merits of the main appeal, in other words, if the main appeal is dismissed, then the court does not necessarily have to reach those, but it would be, because of the public importance of this matter, it would be recommended that the court pronounces itself particularly on the breach of the oath by people who have been entrusted with these kinds of powers, except for the issue of prematurity and ripeness, because that point is symbiotically linked to the ultra-virus point. Because if indeed it is ultra-virus, then it means the National Assembly will deal with it on the 14th of June, and therefore there's no urgency. And the phantom date of the 29th of May is just a make-believe. So that's I'm sorry. Yes. Yes, I'm reminded of two quick points. First one is that to conflate the powers of the parole board, as the amici are doing, with the prerogative powers of the president is just an absurdity. Because the powers, it might well be that the parole board, for whatever other reasons, as a power to pardon or parole or do whatever. But that's a completely different thing to the exercise of the presidential powers. The other point, small point, is that the amici, and that's really why there's no need to address them. The amici make the following fundamental point on the international law, and also on the travel préparatoire. On both counts, those instruments, let's call it that, cannot defeat the clear words of Section 39.1a. Section 39.1a says that this court must promote the values, 39.1, not 1a, yeah. Must promote the values that underlie an open democratic society based on human dignity. We've dealt with that. B, must consider international law. And C, may consider foreign law. So the foreign law is an optional extra, and we know the conditions that it can be used. But it must consider international law. And international law cannot then be compared to the to these discussion notes. By the way, Justice Bilgit, we all know from Makwanyane, paragraph 18 of Makwanyane, that it was said there that those preparatory notes must be consulted if, one, they are clear, two, the question is clear, two, they're not disputed, which doesn't apply here, and three, they show the reason why a particular provision was met. But the point we make here is that our learned friends even said yesterday in their heads, we could not find any case that is on point. But that's not true. There's a case of Disanayake, which is directly on point on the conviction point. And that case says, this is how we even characterize it. That case, by the way, was discussed in the rescission judgment by Justice Jafta, Disanayake. So I don't know why my learned friends could have missed it. Because it was discussed. You'll remember Justice Khampepe even made this distinction about the ICPPR as to whether, although it was ratified by South Africa, was it domesticated and so on. It was exactly in response to Justice Jafta's analysis of Disanayake. And that case sorry.
Perhaps you can trust us to read it for ourselves if we have not already read it, Mr. Booth.
Yes, I do trust the court. But if you just allow me, Justice, to make this point. We say in our words that Disanayake, the facts are broadly as following. We say, like Mr. Zuma, Mr. Disanayake was convicted, quote unquote. Like Mr. Zuma, he was convicted for contempt. Like Mr. Zuma, he was subjected to a disqualification to go to parliament. And the forum, I think it was the UN committee, found that that cannot be. It found that doing so was denying Mr. Disanayake's right under Article 25 of the ICPPR. Article 25 is what our Section 19 is modeled on, which is the right of every citizen to vote. So that case is on all fours, it's available to everyone, but somehow it escapes all our learned friends' attention. And that shows you that international law, both in terms of Article 9 of the ICPPR, Article 9 is the one that talks about the right to a trial, or the right not to be detained without trial. Article 14 talks about the right to a trial and to appear before a judge. And Article 25, which is the one that we're talking about, is a mirror image of our Section 19. So in international law, this case would be laughed out of court, because they would say, this is exactly the very same calamity that Mr. Disanayake in the Sri Lankan court was being subjected to. And international law is totally against the denial of voting rights in those circumstances. As a court, please.
Thank you, Mr. Mpofu.
I'm indebted to the court.
Mr. Mpofu? Can we deal with eligibility to be a member of the National Assembly?
Yes.
What is the advantage of being on the candidate list? And if you are not on the candidate list, can you be a member of the National Assembly?
No, of course not. You can, by the way, in a different way. Remember, parties...
Let's answer the first one first.
Yes, the answer is yes, you can.
Yes, but I'm saying the first one is, what is the advantage of being on the candidate list?
Well, there's no legal advantage, to be honest, because it's what we call in law a space. It's a hope of so many uncertain things. One, that your party is going to get a seat in the first place. And two, as I say, that you are, if the party gets elected, out of the 15,000, you'll be one of the 400. That's the whole point, Justice Chikwi.
And then the second question.
Yes.
Would you be a member of the National Assembly if you are not on the candidate list?
You could, in the following way. When the law is a bit fuzzy on this, it says that so theoretically the answer would be no. But let me tell you how it actually works. So, in terms of the list...
When you say theoretically no, is that in terms of the act, or is that how it's done practically?
No, but both practically and in terms of the appendix. This is what it says. So you have 20 members, and you get 10 seats, let's say. So theoretically, once one of those members resigns or dies or whatever, you go to number 11 on that list. But what happens in practice is that a party will replace, quote unquote, as it happened recently with many other MPs, will replace that person with the person that they want to go to Parliament. And that person simply gets sworn in. The example of Advocate Mkhwebane and people like that. So they were never in any election list or anything like that. But the party is capable of, so to speak, re-engineering the list so that the outcome that they want happens.
In the upcoming elections, what is the advantage of being in the candidate list? In
this coming election?
Yes.
Again, it's a speculative advantage. So I have to make that qualification because it depends on one, and we've made this point candidly in our papers. We said in the case of Mr. Zuma in particular, you have to postulate, and Justice Machit raised this, you have to postulate that A, his party will be elected, B, he will want to go to Parliament despite what has been bandied about losing presidential powers and so on, whatever the correct answer is to that. And that he will specifically want to go to the National Assembly and not the NCOP, for example. Now, all those things, that's why I use myself as an advantage. Those are, as an example. Those things are, probably not going to happen because you have to postulate all of them. That's why we say that this agency is more myopic than real. So the question, Justice Chikwi, which I think you are alluding to, is the following, and it's what our colleagues say and what Justice Zonde say, that for you to hold office, the right to hold office comes from the right to stand. But that's not true. Because these are two distinctive rights. The right to stand, which has been isolated in Section 31A, as the right to stand in an election. That's what all the 15,000 people have exercised, the right to stand. That's a completely different thing to the right to be eligible for the National Assembly. Let me give you an example. It is possible that whenever the date was, I think it was the 8th of March. On the 8th of March, when you submit your list, that candidate X does not qualify to be a member of the National Assembly. Why? Because the 5-year period for him or her ends in April. But that does not mean that when the National Assembly sits on June, that person will be disqualified. Because that is why our learned friends had to re-engineer the section. If you look at the heads, their heads. They say because it says Mr. Zuma has been sentenced. One of the amici says because Mr. Zuma was sentenced. That is an impermissible re-engineering of the section. There is a reason why the drafters of the section use the present tense is. They say anyone who after this section took effect is convicted of an offense and sentenced to more than 12 months. What does that mean? It means at the point of testing eligibility is now, today.
Sorry to interrupt you.
Yes.
Mr. Kofu. Is the present tense there not related to what happens after the act has been promulgated?
No. That's a different clause. It says anyone who after this took effect, comma, so that means that's a timing thing. It can only take effect after this section. But it says anyone, and that's why they had to change it in their heads, who is, as at that point, whatever the point, let's forget for now.
After this act,
Is, yes.
Yes.
That is not was, is convicted. That means on the date of the testing of eligibility, we will know that Mr. Zuma's sentence was already reduced. So is he now, not was sentenced and what have you, is he at that point disqualified? The answer is no, because he's been given a remission by the president. So the choice of the word is cannot be engineered and used, as I say. If you look at their heads, they say has been convicted, because they know that on the proper construction of the section, the testing point is now, and the testing point. Let's sorry, if I can just finish this point here. Let's assume now I'm wrong about whether the testing point is in June or March or whatever. But the point is that at that point, whichever one it is, you have to test, is he eligible? Because remember, the converse also holds, Justice Chief. You might be ineligible at the time of the submission of the list and eligible at the end. But the vice versa also holds. You might be eligible at the time of the list, but something happens in the 2 or 3 months which makes you ineligible. So to conflate those two things is just legal sabotage.
I hear you. I understand the section, the way they have interpreted it.
Yes,
but I've heard you. Let's look at Appendix 1, because
right.
The reason I'm asking you about the advantage of being in the candidate list. It seems to me that, am I correct to say one of the conditions? Because the IEC wants you to declare that the candidate on the list is qualified to stand for elections in terms of Section 47 or Section 106 of the Constitution of South Africa. So it's one of the conditions. Basically, what the IEC is saying is that we must declare that that candidate.
New business. Sorry. Yes, Justice.
That candidate conforms with this. What is the effect of that?
Yes. Well, the effect of that is nothing, because this court has said in the new business case, paragraph 145 of our heads. Okay. Yes, the appendix is at 145, but the case of new business, which is what I'm looking for now, is do
you mean to say Afri-business?
No, yes, it's Afri-business. Afri-business, that's correct, yeah. Now, in that case, this court made it very clear that you cannot have, to borrow one of my learned friends' phrases, have the dog wagging the tail or the tail wagging the dog. Regulations by their nature must conform with the act that gave birth to them. But more than that, they can also must conform with the Constitution. So you can't have a Constitution being construed in the eyes of a regulation. That's just ridiculous. What you do is to look at that regulation, and if the regulation is somehow inconsistent with, in this case, Section 31A or the Constitution, then of course you can't have the tail wagging the dog. So you can't. Then that's one of the fundamental mistakes that Justice Zondi J.A. did, by the way, because he said, no, there is this appendix, and therefore Section 47 applies. The other fatal mistake he made was to say in the Winnie Mandela Freedom Front matter, that court proceeded on the basis that 47(1)(e) applies. But so what? If that was not argued in that case, you can't say this court now is bound by that, because the court is confronted with that issue. But as far as the regulations is concerned, that means absolutely nothing, because but by the way, let's assume the regulations apply. What does it say? All it says is that Umkhonto weSizwe Party said that Mr. Zuma is not hit by 47(1)(e). That's what it still says today. So I don't know what's so magical about the appendix. That's exactly what I've been saying here all day, that is not hit by 47(1)(e). So when they made that declaration, it's not like they've changed anything. But the real legal answer is that the regulations cannot defeat the statute.
I hear your submissions.
Yes.
Let's go to the effect of the conviction and sentence for contempt of court.
Justice, can I ask for a small favor? I don't want to interrupt you. I just want to give the reference of this case that I referred to. Yes.
All right.
It's at page paragraph 174 of our heads, Afri-Business. Thanks, Justice Majid, where it was said that regulations must be considered in relation to the empowering provision under which they have been made, no matter how clear and unequivocal such regulations may purport to be. Thanks. I just wanted to get that off the way. Thanks.
All right. It's late in the day, so I'm a bit rushed.
Yes. I'm a bit fluey, but I'm soldiering on.
You said that if a person has been convicted of contempt of court, and I'm going to allow you to qualify it because in your argument you made a distinction between criminal matters and civil matters. Yes. But you said that in respect of civil contempt, that person has not been convicted and has not been sentenced. Did I hear you correctly?
Yes, you did.
I'm going to ask you what may seem to be a silly question, but it really bothers me.
Yes, Justice.
We know that Mr. Zuma was imprisoned.
Yes.
So was he imprisoned without being convicted nor sentenced?
No, that's another tail wagging the dog kind of argument. Yes, we know, and that's why one of the justices referred, I think it was Justice Majid, referred to the issue which was raised by Helen Suzman Foundation, that he was not a convicted offender and therefore he didn't qualify for parole, which was correctly rejected by the SCA. No, it can't work like that, Justice Chick. And it's not a silly question. It's a legitimate question. Because at face value, again, remember we say, at face value, and that's why I agree with my learned friends, a proviso and a deeming proviso at that, its function is to say that which at face value looks like is not that. That's what a whole purpose of a deeming proviso is. So the purport of that is the following. when we are looking at the word or the phrase, let's start with the phrase, convicted of an offense, which is in section 47(1)(e). That phrase has got two elements. An offense, which we've considered, and the first part is convicted. Now, we are saying, all we are saying, Justice Chikri, is that, and we use as an example this issue of previous convictions, which was raised by Justice Cameron and Faki. Because he was saying that can the committal of a person in civil proceedings for contempt of court be regarded as a previous conviction? Yes. And it was exactly that. That's why I'm saying let's forget about previous for now.
Yes.
What he was really saying was, is that conviction a conviction, so to speak? So it's not a simple question, or that's why I'm saying it's not a silly question, because it is exactly what exercised the mind of that court. But that court decided to leave that open. Why? Because, and they even said what mechanisms would have to be used, because remember, this is not a criminal court. This is what he said. It would certainly be odd to regard the applicant in such proceeding as a prosecutor, not only because of absence of office, but because the presence of manifest personal interest. Well, that's an issue I should have raised this morning. During argument, there was debate about whether a civil court's finding of contempt with concomitant imposition of punishment would count as a previous conviction for purposes of Section 271 of the Criminal Procedure Act, which permits the prosecution in a criminal trial to prove previous convictions in aggravation of sentence. Or whether, if it were, it would feature in the South African Police Service SAP 69 register of previous convictions, and what mechanism might be necessary to ensure that it was so recorded. Neither counsel ventured firm submissions, and the debate was inconclusive. And then he says in the next paragraph that it will be decided by another court. So that court might be this court. And the issue is that, and the point I was making really is a subtle point, which is the mere fact that Justice Cameron left that, because on the interpretation of all my learned friends, the answer to that should have been obvious. But the mere fact that he left it open was because it was not as obvious as it might seem to the naked eye. And that was, in that case, for the purposes of comparing like and like. Now we're even in a worse position where we're comparing a conviction, and I've described what kind of conviction we're dealing with. I don't need to repeat it. So if it can be a previous conviction, then how can it be a conviction?
Well, as you say, this court left it open, and it is your submission that it should not be a previous conviction.
Yes.
And your submission, therefore, then says that there should be a distinction between civil contempt and criminal contempt.
Yes, thank you, Justice Chick. Yes, I'm sorry to cut you. My response to the direction of this court, which was specifically on that question. Remember, there were three questions that were asked to ask. One, is there a distinction between committal for civil contempt, I might be using different words, and the criminal conviction? One. If so, question two was, does 47(1)(e) apply to both types? So that's the question we are addressing. To say, if there is that distinction, then 47(1)(e) only applies to type 1, which is where a person would have had normal Criminal Procedure Act rights and so on. And
if I follow you well then, in your submission, former President Zuma does not have a previous, a record of a previous conviction.
No. Okay, well, let me just say this, because I don't know for sure. I don't know. But that question is irrelevant to the submission I'm making. Because...
No, concerning
yes.
This contempt, the contempt matter, I'm not talking about matters yes. that are not yes. Within your knowledge. I'm saying, if let's look at this very contempt yes. of court.
Well, let me answer it like this. The answer is on that side of the table, not here. Because that's why Justice Cameron was saying what mechanisms might be used. In other words, I don't know if this court, after convicting quote
I'm
unquote.
asking for your assistance because in order for me to make that, together with my colleagues, that answer, I need your assistance, which is why I'm asking you.
No, yes, I'm giving you my assistance, Justice Chief. My assistance is that Justice Cameron was saying, when he says, 28, yeah, he says, and indeed, after what I've said, and indeed these questions are not before us now, and it is not necessary to decide them. I make only the point that they may be better answered not through a rights by category analysis in which the protections afforded depend on whether the respondent is an accused person under Section 35. So it brings us back home. Under Section 35, but by considering the rights in that provision a relevant background source that furnishes values instructive in interpreting the full range of constitutional protections to which the alleged civil contemnor sought to be imprisoned as a punishment for disobeying a court order is entitled. Certainly the requirement that proof should be conclusive and not merely preponderant seems to me to be among them. Now, what is the justice saying here? He's saying exactly what I've been saying all day, that in answering that question as to whether this conviction is a conviction, you have to cross-refer to Section 35, the protections that are provided in Section 35, to use that as your yardstick of defining this animal, because the Constitution itself has defined what a conviction is in Section 35. I think it's specifically L or M, where it says it uses the word convicted. So that's what he's saying, and that's all I'm saying, that and that's why he left it open. If it was a simple thing that a conviction is a conviction, he wouldn't go into these deep philosophical issues about section, the implications of Section 35 on that very question.
Thank you. Just the last comment you might want to respond if you so wish. It just bothers me that if we know that a person was convicted and sentenced and actually did serve a period of imprisonment, we then turn around and say, in fact, this person has no record of previous conviction. It doesn't sit well with me. It looks artificial. It sounds artificial, because then was he sentenced or not? Did he serve time in prison?
Yeah, that's exactly the point, Justice Chief. It's the fact is, was he convicted or not, as you correctly say? Within the meaning of Section 47(1)(e) and the meaning of Section 35, the answer is no. Was he sentenced within the meaning of that word in Section 47(1)(e) and Section 35 of the Constitution? The answer is also no. But if you don't like those answers, then you say, okay, he went to jail. But then he was given a 9 months discount of that and left outside of the scope of 47(1)(e). So that you cannot wish away. So even if you disagree with everything...
Let me interrupt you,
yes.
Mbofu. My discussion with you, it didn't deal with the issue of remission. I'm leaving out that for my other colleagues. I was just talking about the way you said that.
Yes.
A person who has been convicted of contempt in civil proceedings was not convicted and was not sentenced and does not have a previous conviction. Yes. That's all I wanted to debate with you.
No, I'm sorry, Justice Chick. I have to say this. One cannot do it like that. You can't compartmentalize it. What I'm really saying is that it's possible for this court to find in our favor without reaching all these niceties and complex definitional questions. Because if this court, it depends where the court wants to start. If it wants to start with conviction and sentence, then it will have to entertain all this. But if the court wants to just hone in on the issue that whatever sentence, let's assume it is what you described, but it was reduced, that's the end of it. It doesn't matter whether conviction, by conviction, whatever. Let's assume he was convicted in the magistrate court in the normal way, after pleading and so on, and he was sentenced to 15 months, and then he gets remission. He gets remission.
Well, the reason I didn't want to engage you was in the interest of time, because in my prima facie view, remission is different from pardon. And I just thought that perhaps one of my colleagues would pick up on that point. Because I wanted to ask if I were to go, to ask whether the former President Zuma's record was expunged. You saying that remission is equal to a pardon.
Yes.
And my reading of Masemula is that it is necessary for that person's record to be expunged, which is why I was engaging you on whether there's a record of previous convictions and all of that.
Well, if you go, the answer we will find in paragraph 40 of Sibiya. In Sibiya, it is made clear, and it's not true what was said earlier, that Sibiya doesn't deal with remission. It does. Look at paragraph 40. Sibiya says the following, that the sentence is judicially determined. That is not debatable. But the president has got the power to alter, change, adjust, amend, whatever, that sentence to the new sentence, quote unquote. And that's what even Justice Yakub, well, it's a funny thing because the Sibiya case was decided by Yakub J, the father. But Yakub J, the daughter, says in her judgment that the ultimate sentence is, in fact, she says, I would have agreed with Mudiba J. The only reason I'm not agreeing with her is because this remission was a general remission and not to a specific person. Well, we answer that question, that's completely irrelevant. There's no remission that is general. A remission is always to a category of prisoners. It says no murderers, no rapists, no this and that and that. There are about 13 categories that have been specified in this particular remission. So it is neither here nor there that the specification zeroes in on X number of people as opposed to Y number of people. The point of the matter is that when the president, if the president would do such a thing, it could be challenged successfully. Just says, I'm just giving remission in jail just it can never happen. He has to apply his mind and make sure that it is honed into a particular category. Low risk offenders of a particular age sometimes who are therefore minor offenses.
So all those prisoners who were granted remission, their records were expunged. Is that your submission?
No, because all those prisoners, Mr. Zuma, Justice Chick, is the only human being in this country who was imprisoned without having pleaded guilty or not guilty. The only one. Since 1994, well, I'm sure even since 1652. So there's no one else who was ever taken to a jail cell without meeting a magistrate, a judge, or anyone and saying, yes, I'm guilty or not guilty. The only person in this world, well, I'm sure even that is true, is him. So, and that is what we're told that the drafters of 47(1)E contemplated. Really? How can that be?
No, my question was talking to the meaning or whether there's a difference between pardon and remission.
Oh, yes. No, sorry, I missed that part, yes. No, the difference is clear. just, I described that earlier, and it was when I was referring to Justice Matopo's question. Firstly, we have to accept that both of those things belong to the same genre in 84(2)(j). One. Once we accept that they all are variations of the same thing, of the power, of the prerogative power, then we say, okay, among them, because the words are not synonymous, what is the difference? And the difference is this: while they are all powers that supersede judicial determinations, but they differ in impact. And I said that the impact is this. In the case of a pardon, then these are called in England, they're called clemency clauses. And clemency is the generic term that covers pardon, remission, reprieve, what have you. So they are of the same genre. We have to understand that. The second issue is that, of course, they are different. What is the difference? And I say, because a pardon is extinguishing both the conviction and the sentence, while remission is extinguishing the sentence. That's all. And so for the purpose, if I were to use that argument, let's assume the only issue here was conviction. If the only issue was conviction, then you would be able to say to me, Justice Chik, but Mr. Mpofu, you are wrong, and I would be wrong. Because the difference between a pardon and remission would have nothing to do with the conviction. But once we talk, it's what we call in mathematics the common denominator. The common denominator between a pardon and remission is the sentence. So in both instances, the sentence is extinguished. But in the case of the bigger set, both the conviction and the sentence is extinct. That's all. That's the only difference. Nobody can bring any authority that says anything different. And that is why it's important to take it from 84(2)(j), that this is a power that is, by the way, a prerogative power. If it was such a thing that is like parole, then it wouldn't need any prerogative power. It's because it is permitted interference with judicial powers, which is what Sibiya says. Thank you.
Mr. Mpofu, I'm hesitant to go this route of this last line of questioning, but because it's fresh, I'm going to deal with it.
Thank you, Justice.
Before I get to the other question that I have.
Yes.
You've spent an extraordinary amount of time on how, and in somewhat emotive language, how Mr. Zuma is the only person in this country, probably the whole world, who's been sentenced without ever facing charges and so on.
Correct.
But all of this was dealt with in the contempt judgment. I mean, if you look at the judgment, at paragraph 75, you know, just to backtrack, in the second judgment of our colleague Justice Theron, she expresses the concern about the fact that these Section 35 safeguards haven't been observed. And she suggests that the Commission should take the matter to the DPP for criminal prosecution, possible criminal prosecution. But in paragraph 75, Justice Kampepe, on behalf of the majority, says that I'm compelled to point out that I see, and this harks back on what you said about Faki, which you say was left open, the question of conviction and so on. I'm compelled to point out that I see no reasonable way of reconciling the second judgment's reasoning on this particular point with the jurisprudence of this court and the Supreme Court of Appeal, which concludes in no uncertain terms that a contemner in civil contempt proceedings does not fit the description of an accused person for the purposes of Section 35. Now, what I want to say to you is, surely since Faki, the jurisprudence has moved on. We had PECO, we had the contempt. So I don't understand why you're parking at PECO, unless I'm misunderstanding you.
No, you definitely are, Justice Majid. What I'm saying is this, that yes, we accept that and she goes on to say, I've already dealt with this, it is uncontroversial that he was not afforded each and every single one of the protections of Section 35. That's what she says. Now, remember, on a lighter note, I thought we were not going to interpret this judgment. But remember that the question here before you now is a
Sorry, I must interrupt you there. We're not interpreting this judgment. What I'm saying to you is, all of this that you're putting before the court now has already been decided.
No, Justice Machit, I'm so sorry. Then it means really we've just been wasting the whole time. The question before you today is a simple one. That with all these things that Justice Khampepe says, and let's assume that they are a correct description of the committal order, I prefer to call it that. With all those, and when she says he's been denied this, it differs vastly and so on. With all those things, those issues, does that committal order amount to a conviction in terms of Section 47(1)(e)? And to answer that question, it is inescapable that you have to say, what does the drafter of the Constitution understand by the word convicted? And that you can only understand by going to where that word is first used, before 47(1)(e). That word is first used in Section 35. So this is a different question. So this accusation of relitigating whatever is wrong. Because the point is, accepting this as it is, was it within the contemplation of the drafters of the Constitution or not when they did 47(1)(e)? This is a very simple question. So you define the animal as it is, and you say it has this, it has 3 legs or whatever, but is it in that form what was envisaged by the drafters? That's all.
I think I'm going to leave it there because I think we're going in circles. We traversed this earlier in the recusal. But let me go to another point. This is one of the points that you called a preliminary point. Mm-hmm. I was startled by your submission that eligibility is determined by the National Assembly and not by the Commission now. If I count correctly, since 1994, this will be our 7th national election.
Right.
In the past 6 elections, do you know of any instance where the National Assembly determined eligibility after the elections?
Yes. That's exactly what 47(3) tells you. That's why I'm saying, what year is this? 2024. If somebody next year in 2025 becomes an unrehabilitated insolvent, what must happen? Must go to the IEC? No. It's the National Assembly that will then determine. That's why 47(3) says...
Sorry, no. Let me just correct.
Yes.
Let me just help you there.
Okay.
I'm talking about we have elections.
Yes.
And then, I'm not talking about midstream, I'm talking about after the elections.
Yes.
Are you aware of any instance where the National Assembly has determined eligibility after the elections?
No, but that doesn't make any difference. The fact that something has not happened before doesn't change the law. The law is about when is it constitutionally supposed to happen. And Section 57 of the Constitution says the National Assembly must determine its own arrangements, and one of its arrangements is this issue of determining eligibility. It happens all the time. There was a gentleman called... who just passed on recently in the Tshwane municipality. He was made a mayor of that municipality, and then it was discovered, I think, a week later that he was an insolvent, and he therefore lost his mayorship. That council in Tshwane did not go to the IEC for that. It determined the eligibility there and then, and the man was taken out of the mayorship. That's what happens every day. That's the job of the National Assembly. If you do something there and they want to kick you out even just for the day, they'll kick you out for the day. But if they want to kick you out for life because you fall under 47(1)(e), they'll kick you out for life. So it's not anything difficult. The National Assembly is, by the separation of powers, imbued with the powers to determine those things. And I'm not being disrespectful, Justice Machit, but remember the rhetorical question I asked. The rhetorical question is, where does the IEC derive the power to decide eligibility? Nowhere.
Okay, let's go there because that was my next one.
Right.
Let's look at section 30 of the, let me backtrack. I asked myself, how did we get to this court? Just to recap. There were 22 parties or persons or entities that objected to Mr. Zuma's nomination. 2 of them were upheld, 2 of them were considered, including Mr. Nkosi. Then the IEC upheld the objection. Then in terms of section 30, you appealed to the electoral court, and the commission's unhappy with that decision is in before us. So, section 30 says, any person, including the chief electoral officer, may object to the nomination of a candidate on the following grounds.
Right.
The candidate is not qualified to stand in the election. Where does that come from? Section 47(1)(e). You agree?
No, it comes from section 19, primarily. 19.3b. Section, how can it come from for section? There's no such words in section 47. You will not find them. It's not there. Those words come from 19.3b. And from the first part of 19.3b, you will find no such word in section 47. I can show you.
I must tell you, I read it differently. The IEC says they saw this disqualification because of section 47(1)(e).
Yeah, that's what
and that's exactly what you said in your notice of appeal. In your notice of appeal, your application for leave to appeal at page 2449 and following.
Yes.
You sought, in terms of section 22b of the ECA, or the Electoral Commission Act, you sought leave to appeal against the decision upholding an objection to the nomination. That's in terms of section 30.
Yeah.
And one of the grounds of the appeal is the IEC exceeded the limits of its power of jurisdiction and authority in purporting to implement or apply section 47(1)(e) of the Constitution.
Yes.
So that is how we got here.
No.
And I don't understand how the National Assembly would, after an election like this, consider the eligibility of candidates before any other business.
Okay, let me assist you, Justice Machid. Let's take a simple example. For you to be the president of the country, you have to be a member of parliament, right? So when the election of the president happens, and if I stood up there and said, I'm nominating my learned friend, Mr. Muela, they will say, no, but he's not eligible because he's not a member of parliament. So eligibility, whether it's for the membership, whether it's to be a speaker or to be the president, is determined at the first sitting of the National Assembly, by the National Assembly. And I don't want to sound like a broken record, but where is the power that gives the IEC, where does the power for the IEC to do that job derive from? Nowhere. Unless if somebody shows me where that power comes from. It certainly doesn't come from 71E, we've just established that. So it comes from...
Well, we haven't. In my own mind, we haven't. But carry on.
Well, okay. One thing we have established, which is undeniable, is that the words to stand for election do not appear in 47(1)(e). That one I'm prepared to lay my life for. It's not there. So how can it derive from a place where it doesn't exist? Those words come from 19.3, the first part of 19.3. That is why that section 47Y starts with the words, every citizen who is eligible to vote is eligible to be a member of the National Assembly. It takes us to section 19. There is no link, Justice Machid, no link, and I'm challenging anyone to show me where the link is between 47(1)(e) and section 31A. There isn't.
Well, I think the submission has been made that section 19 is the general right, and that right is qualified in section 30, which says that you may object. Now, on what basis was the objection then considered? by the IEC, on what basis could they consider the objection, the objections?
In actual fact, no, they could. Okay, that question is quite appropriate. They could, or at least they are legally permitted to entertain an objection that is about the right to stand for an election. That they are entitled to in 31A. It's not debatable. But the minute they stray into the other right, which is a contingent right, by the way, which says if elected, you can hold office, then they are exceeding their powers. So you asked the question correctly. What could they do? They could certainly determine the issue of standing. Let's say, for example, they said, look, you can't stand. That's why 47.2 differentiates between standing and eligibility. It says, although the people in A and B are not eligible, but they are allowed to stand. Why is that differentiation made? Because for practical reasons, I might be a DG or something, and some party wants to put me on their list. Then 47.2 says, for that reason, because I'm ostensibly disqualified in 47.1B or C, I can still stand, but obviously subject to I must resign or whatever must happen by the time the National Assembly determines. Otherwise, that section would not make sense, Justice. If this conflation which is being done in this court between the right to stand and the right to hold office was true, then 47.2 would be an absurdity.
But 47.2 has got an important proviso. It says, subject to any limits or conditions established by national legislation.
Yes, that's why I'm postulating those might be you have to resign or you must put notice or whatever. But the point of the matter is that that section distinguishes clearly between the first part of section 19.3b and the second part. And what the IEC did wrongly was to stray beyond the powers that have been limited by 31A, which limited only to the first part of that section. That's all. So it jumped to do somebody else's job, and in doing that job, it then exceeded its powers. That's what ultra-virus means. So it exceeded its powers that are in section 190 of the Constitution. Because remember, 190 says, they must arrange elections and so on and declare a result. And then 192 says then they might have any other powers defined in legislation. So which legislation gives them this power? Because section 31A certainly doesn't do so.
Yes, it doesn't quite answer my question, but I'll leave it there. Thank you.
Mr. Mpofu.
I'm sorry, Justice, if I may just mention. Okay. Sorry, Justice Campbell. If I may, yes, something has just been brought to my attention, and I'll just make the point. I won't even develop it. That section 27(2)B of the Electoral Act, remember they claim this power that they used was, they now claim in the current papers that it was from section 30 and section 27. But that section says the Electoral Act must be, 37(2)B says the list or lists must be accompanied by a prescribed declaration signed by the duly authorized representative of the party that each candidate on the list is qualified to stand for election in terms of the Constitution. It doesn't say in terms of section 47. And that must mean in terms of 19.3b, yes, B, the first part, or national or provincial legislation under chapter 7. So
no, but why does the Constitution only go as far as section 19 for this purpose?
Why?
Why does the Constitution only go as far as section 19 for this purpose? It doesn't go beyond that. What about 47?
No, nobody has said that, Justice Machid.
No, but you just said so.
No, I never said.
It can't mean 47, it must mean 19.
No, I never said such a thing, Justice Machid. I'm saying that the primary resort in a constitution is the Bill of Rights. One, okay? that Bill of Rights, as defined in Section 39(2), is hierarchically superior to any other provision. And therefore, you cannot jump to Section 47. You have to construe, as was said in the Freedom Front case, you have to, when you are looking at Section 47, you cannot start, and that is what Justice Madlanga said in the New Nation matter, that you can't just go to Section 157. You have to do it within the normative framework of Section 19. He was not meaning that the Constitution ends at Section 19. He was meaning that in interpreting any other provision, you have to steep it within the framework of Section 19. Because after all, and that is why in August, this court said, you cannot take away somebody's electoral rights by silence, which is what is now being said. You can't say, well, look at Section 30, it doesn't, no. If you're going to take someone's electoral rights, you must say so. You can't say you do it by silence or by implied engineering. So what would have stopped the people doing Section 27 or Section 30 from simply adding the words, or the right to hold office? Or say in this section, in terms of the Basbe Declaration, in terms of Section 47 of the Constitution, nothing.
I hear you. Now, would I be wrong if I say that the other interpretation that's possible is when you interpret Section 47(1)(e), you must do it in the context of upholding the right in Section 19? Would it be wrong to say that?
No, that's what the cases say.
Yeah, thank you.
Yes,
thank you.
August in particular, sorry, Justice Majid. The case of August is very crucial because I think it's paragraph 17 of August, which says that it says that a provision that deals with the franchise must always be construed in favor of enfranchisement and not against disenfranchisement. That's the first thing that's said in August. And I think in paragraph 34 of August, then the point is made about that you can't take away somebody's rights by silence or by some implication. So you're quite right, Justice Majid. Our cases, and this was cited with approval in all the Section 19 cases, the seminal passage of Justice Sachs in August.
Mr. Mpofu, right at the beginning of your address and more recently in discussion with my brother Majid, you asked where the IEC, what the basis was for the IEC decision. Mm-hmm. And you asked, did the IEC have any power to disqualify Mr. Zuma? Perhaps I can ask you to have a look at the record at page 246.
Yes, I'm there.
As I understand the procedure, and we dealt with matters similar to this earlier in the week, the parties compile lists of their prospective candidates.
Yes.
The process then continues under section 30 sub 3. The Commission must decide the objection.
Yes.
In other words, it must decide is the objection good or bad.
Yeah.
And must notify the objector and the party. It doesn't inform the candidate that the nominated candidate of the decision in the prescribed manner. And then in subsection 4, the objector or the party who nominated the candidate may appeal against the decision of the Commission to the Electoral Court in the prescribed manner. court, and then sub 5, the electoral court must consider and decide the appeal and notify the parties. The power of the IEC to determine that the second respondent was disqualified is to be found in section 30 sub 3. The Commission must decide the objection. It decides the objection, it upholds the objection, and thereby disqualifies the second respondent.
No.
And thereafter, I'm sorry if you allow me to finish. Thereafter, there's a process involving an appeal, which ultimately lands up in the electoral court. And that's why we're here, because of the electoral court. So I'm suggesting to you that there is a clear basis for the IEC having exercised its power of disqualification. And I'm just pointing that out.
Yes. Okay. May I respond? No. That's the most incorrect way of determining jurisdiction, because that's what ultravirus means. It's jurisdiction, sometimes called authority. So you can't derive jurisdiction from the fact that you exercised it wrongly. So if I bring a crash and bash motor accident case in Cape Town when the accident happened in Johannesburg, I can't go to the sections of the Superior Courts Act and say, yeah, but court, you have the right. But they say, yes, we have that right if we have jurisdiction over the matter. So that's why jurisdiction is discussed up front. So it can be, you can't lift yourself up by your own bootstraps and say simply because you have a power to decide an objection, therefore you don't have the power to determine whether that objection is in the right place in the first place. Or you bring a claim that is supposed to be in the magistrate court or whatever, or in the labor court for that matter. If you go to the High Court with a claim that should be in the labor court, then the first thing that court must do is to determine its jurisdiction. Does it have the power to determine that? It can't say, yes, because we are the High Court, we're going to determine this. And then afterwards, we're going to, the case of Makanya, Kaba, Chirwa, make that very clear. That the jurisdiction point is a primary point. You can't derive the power to do something wrong from the fact that you did it wrong. And by the way, sorry, Justice Campbell, one of the criticisms which have not been addressed, which we level against the IEC for exceeding its powers, is because if you go at 290, Justice Campbell, 290, and this is the point that Mr. Ngogaitobi was asked in the electoral court. Okay, if you're saying this thing ended on the 11th of because there's a second proviso, let's not forget, about the 5 years. And he was asked, when does that 5 years start or stop? And he couldn't answer the question. And that's because this is what Mr. What's his name? No, it's not Mr. Nkosi. Okay, this was a response to him, but Dr. Matsapul, the one that is before Nkosi, said he abandoned his objection. So the only objection before the court now is that of Dr. Matsapula. So Dr. Matsapula, to use your analogy, Justice Campbell, had pleaded his case, if you work with me. So when he pleaded...
Sorry, Mr. Mpofu, I wasn't debating with you the question of jurisdiction. You were asking, you repeatedly asked, where the IEC sourced its power to disqualify the second respondent. I'm suggesting to you, it's got nothing to do with jurisdiction. I'm suggesting to you that that power vests in the IEC by virtue of the Electoral Act, by virtue of Section 30. That's all I'm suggesting to you.
Well,
if you don't agree, that we can agree to disagree.
Well, thank you. No.
Thank you.
Well, it's the first time that I hear that the power of a tribunal to do something has nothing to do with jurisdiction. That's what jurisdiction means. It's the power to determine a question. The power and the authority to determine a question. That's what it is. It has been said by the SCA, it has been said by this court, that it's the power to determine something. And all I'm saying, Justice Campbell, is that the IEC does not have the power to expand the objection, even using your 33. Dr. Matsapula says, Mr. J.G. Zuma completed his sentence when he was released from prison on 11 August 2024 following a special remission of sentence in terms of Section 84(2)J of the Constitution for certain categories of sentence offenders. The person who's really objecting, to use those words, is defining the ambit of his objection. To accept that the sentence ended on the 11th of August. The IEC impermissibly brings a different case here, which is not confined by the pleadings, quote unquote, of the objection that it is supposedly determining under Section 33. You cannot do that. Even a court of law doesn't do that. The court can say, oh, well, you've pleaded that you lost a car, but we think you've also lost a bus. So therefore, we're going to determine it outside of the jurisdiction which you, as the objector, have defined. That's really the point I was making. And jurisdiction is defined in Baxter, in Hoekstra, and all the literature as the power to determine something. Actually, even in the old cases, before the Constitution, I forget the name of the case. It was in the 1920s. It was said that by NSCJ, jurisdiction means the power of a court to entertain. I think that was the word, to entertain something.
Mr. Mpofu,
Thank you.
I'm really sorry to belabor this point, but
Yeah.
I'm confused about it.
Yes.
And perhaps in the meantime, you can ask your juniors to find in the papers the respondent's response to paragraphs 35, 36, 37, and 38 of the applicant's founding affidavit.
In this court?
Yes. And this is the question. You rely on 19.3b, and it says to stand for public office. It goes on to say, and if elected to hold office. If I understand your submissions correctly, you say that the authority or the powers of the Electoral Commission only extend to the first part of 19.3.
Of 19.3b, yes.
Now, this is my question, and it may seem like a very uninformed one.
Yes.
A person who stands for public office, if they are elected to the National Assembly, does it mean then when they are in the National Assembly, they are holding office?
That's a good question, Justice Teron. No. What it means is, there's this thing, the Americans call it president-elect. That's what you are called before you are sworn in. So you get voted in, and then you are known as the
Okay, let's cut to the chase. Once they voted in, are they holding office? No,
not yet. Until they are sworn in, they are not holding office.
So when they are sworn in, they're holding office?
Absolutely. That's why I think somewhere in the papers we call them MPs elect. So they are in that interregnum between the 30th of May, let's say, and the 14th of June. Everyone, including the president, by the way, is called the president-elect. Why? Because until the day that he is sworn in, he cannot be called the president. So similarly, those people, when they are in that twilight zone, they are, and I've made this up, members, MPs elect. And at the point of their swearing in, then they become members.
Let me follow up on that. Do you agree that if a candidate is not allowed to hold public office, they're also not allowed to stand for office?
No, I don't agree. Let me explain why. Because it is conceptually possible, Justice Teron, for someone, as I think I was responding to Justice Chik, for someone to be, let's call it objectively ineligible in March when those lists are put there. But their 5-year period is ending in April.
Yes, but Mr. Mpofu, we don't interpret legislation having regard to particular people's situations. We look at the legislation and we see what it means.
Okay, well, the answer is, the short answer then is yes, it is possible to be to be disqualified from standing for office, which is what 31A, but be qualified to hold office later. That's the answer.
So,
And vice versa.
At the time when you're disqualified to stand, when you're disqualified to hold office, at that time, say that's the election time,
Yes.
it also means that at that time you're not qualified to stand for office.
No, it doesn't mean that. It means that the National Assembly, when it determines eligibility at some future date, that's why the word is used, and that's why I was making that point. It must determine at that point whether this person is disqualified
Do
or
you have any
ineligible.
authority for that submission?
No, well, it's the dictionary. Is means the present tense. So it means
Do you have
the...
any authority for the submission that at the time of the election, if the the candidate is not qualified to hold office in the National Assembly, they are still qualified to stand in the election?
Yes, the authority is the law, Justice Taron. It's the section itself. Remember that if this interpretation was correct, the one that you are posing to me, then it would mean that the job of the IEC would be to look at all the 15,000 people who are candidates, to determine all these things. But that is not the case, exactly because when the issue of eligibility comes, it's not going to be for 15,000 people, it's going to be for 400 people. And who are those 400 people? It will be the 400 people who at that time are vying to be MPs, for lack of a better word. So
let's go to the first and second respondents' response to what is set out at paragraphs 35 to 38 of the founding affidavit.
35
what is the response and where do we find that, please, Mr. Mpofu?
Okay. I'm told, I think we made a qualification there that the responses would not be, is it 472? 472? Yes, it's at 472, not itemized as adversarial team, but this is the, what we say, paragraph 73, Justice Taron. Yes. I'm informed that I won't read it all, obviously, but that response starts from paragraph 73 to 80. But let me just read the first part. We say, Section 471 is also very clear in that not only is it located in Chapter 4 of the Constitution, as opposed to Chapter 9, where the Electoral Commission is to be found, but refers specifically to eligibility for the membership of the National Assembly, and we underline that in Section 47.1. As if that were not enough, in Section 47.2, the Constitution clearly distinguishes between the separate legal concepts of eligibility for the National Assembly membership and candidacy for elections. Section 30 of the Electoral Act specifically refers to candidacy for elections and not to eligibility for membership of the National Assembly. There must be a logical reason for this distinction. And then we go on about Rule 13 and the separation of powers, and then we say that in paragraph 75, we refer to Freedom Front. I've made those points. And then we say, furthermore, the declaration which is found in regulations which constitute subordinate legislation can never trump the clear provisions of the Constitution or even the legislation which gave birth to those regulations. And I'm going to jump to paragraph 80. We say, it is unfortunate that the Electoral Court completely missed the crucial point that even Ultra-virus objection does not concern whether Mr. Zuma was eligible or not for membership of the National Assembly, which is an issue for the merits. But the primary question of who is legally empowered, empowered to determine that question, whatever the correct answer may be. So it's, in a nutshell, what we're saying there is that assume for present purposes that Mr. Zuma is not eligible. But if the body, the constitutional body that takes that decision is not one that is empowered to, then on that ground alone, the IEC would have strayed beyond its powers. Yes.
I would like to clarify the aspect of the directions that were sent by this court. The directions did not focus on the difference in the nature of proceedings. The question posed, the first question, was the effect of a conviction of civil contempt as opposed to criminal contempt.
Yes.
And the effect, that question must be answered with reference to our law. And in terms of our law, there is no distinction. Once the conviction takes place, there's no distinction after that. Before that, in the proceedings are different. But civil contempt is recognized in our law as an offense. Yes. And once a person has been declared or found guilty of civil contempt, that is a conviction.
Well, I don't agree with Justice Taron. That's what Justice Bilhitz was saying, about which was considered correctly by one of my learned friends, that this distinction between so-called substantive and procedural rights is illusory at best. How can it be that the, let's call it, the mother of the conviction is in breach, let's say for argument's sake, of Section 35, but the child of that process is not. It cannot be, because Section 35, although...
Yes, I don't mean to interrupt you.
Okay, I'm sorry.
It may be difficult to accept, but that's our law, Mr. Mpofu.
No.
And that's what this court and the Supreme Court of Appeal in particular has said in decisions.
So, Justice Taron, please, if you can allow me to finish my response.
I'm sorry, please continue.
Thank you. I am saying that our law does make a distinction between a so-called civil contempt contemnor and a criminal accused. And the way that bridge is, or rather, yes, that gap is bridged, is by what you suggested, Justice Taron, that the matter should be referred to the magistrate court or wherever, so that that gap is closed. Because then, if that had happened and Mr. Zuma was sentenced to 15 months, we wouldn't be here. Because who would come here and say it's not a conviction? But to argue that a civil contemnor position in our law is the same as that of your run-of-the-mill criminal offender is wrong. That is why Justice Cameron posed that question in Faki, whether that person, in example A, can be said to have a previous conviction.
The effect of the decision of the Electoral Court is basically to nullify a decision of this court. And even though I may not agree with the contempt judgment, I'm not sure if a consequence that nullifies a decision of this court is something I can live with. And I'm speaking just for myself now.
Yes. No, that's a valid question. But as we discussed this morning, whatever the views might be out there, what the Electoral Court did was not to nullify this decision. So Mr. Zuma cannot now suddenly say, oh, well, the Electoral Court said for the purposes of Section 47(1)(e), I was wrongly convicted and therefore I'm going to claim from the state. No. That is what would have happened if the Electoral Court would have nullified. All the Electoral Court did was to ask a very simple question. Did the crafters of Section 47(1)(e), when they use the term convicted and sentenced, have in their contemplation the situation of Mr. Zuma, which we've repeatedly described? And our answer why that cannot be so, Justice Taron, is because we say, okay, I know the Constitution doesn't get drafted like that, but Section 35 had already defined those rights.
Let's assume I agree with you, Mr. Mfofo, that the drafters of Section 47 may not have had this scenario in mind or contemplated it, but we sit with the scenario.
Yes.
The one way to go is the way that the Electoral Court went, and to say it's not a conviction or a sentence for the purposes of 47.
Yes.
I have difficulty with that, as I put my first difficulty to you. The second difficulty with that, with the consequence of the decision of the Electoral Court, is that somebody who falls into the category of the substantive disqualification, the consequence of the decision of the Electoral Court is exonerated. There's no consequence. So that person is automatically excluded from the disqualification. And let me preface that by saying to you, as I said before, that the drafters didn't contemplate this, but this is the situation that we are sitting with. And perhaps this court, well, I'm speaking only for myself, maybe if we're forced to choose the lesser of the two evils, would it be to say, having regard to the majority judgment and the serious nature of the offense as articulated in that judgment, in this circumstance, it would be in the interest of justice that this court says, even though this may, and I'm only articulating my view, this may not have been a situation that had been contemplated by the drafters of Section 47(1), that here the proviso will not come into operation because of the final nature of the sentence handed down by the Constitutional Court.
I understand that. No, this court cannot do that. And I don't want to go back to the submissions I made in the recusal application, that this court might feel affronted by what the Electoral Court did. This court cannot do that because to do that would be really what we call double jeopardy. Because this court would now be saying for the second time, we're going to use a punitive provision against Mr. Zuma specifically, just because the Electoral Court did something that is wrong. But that's exactly what August, FF Plus, and all those cases says you cannot do. Because they're saying you must, if you are faced with that dilemma, you must decide in favor of enfranchisement, not disenfranchisement of Mr. Zuma. That's what those cases say you must do in that situation where there's really a choice to be made. It has to be done in the spirit of Section 19 of giving human rights rather than taking them away. So whenever, and we know, Justice Taron, that situation in all the relevant cases is postulated exactly for that. For a situation where it's not an easy choice, where it's 50-50, let me put it that way. And then it says that then the court must err on the side of enfranchisement rather than disenfranchisement. So this court cannot then want to punish Mr. Zuma, punish the MK party, punish all those people who may have wanted to vote for him, take away their Section 19 rights, just to correct this. But secondly, and as I said to Justice Chipre, even if Justice, and that's why I'm saying this court has a way of not getting into all these things. Even if you are right, Justice Teron, and the solution is to say, look, we're going to err on the side of disenfranchisement, that still would be dealing with the first issue of the sentence, the definition of the sentence. But the issue of the remission cannot be answered in that way, because that issue, which could be the primary issue, is in, and that's why I said to Justice Chipre, assume there was not all these complications, and this was a straightforward sentence from a magistrate court of 2 years. And then there was remission, where you take away 15 months, let's say, and it becomes 5 months, whatever the difference is, a 9 months sentence. At that point, if you accept the definition of remission, even if it was a normal sentence, you still cannot punish, because you still have to apply the section to favor enfranchisement. So you cannot then, on what basis could you say, yes, I know the sentence was reduced to 3 months, but for the interest of justice, we must disenfranchise Mr. Zuma?
The substantive disqualification in section 47(1) does not refer to effective imprisonment or time served.
Yes.
It refers to the sentence imposed.
Yes.
And the imposition of sentence is a judicial function, as I understand it. There are authorities who have the power afterwards to shorten that sentence. There are authorities who can decide the minimum term of imprisonment. That's not what 47, as I read it, is asking. 47 is saying, if you have been sentenced, and you're sentenced by a court, and I know this is 2 questions in one, my understanding is that there's a difference between pardon and between remission. Pardon expunges the record. Remission reduces your sentence.
Absolutely.
With the effect that you serve a shorter period. But the fact that you may have served a shorter period in prison due to early release on parole or due to a remission being granted, does that change the sentence imposed by the judiciary?
No, it doesn't. It does this, Justice. You see, the 2 problems with what you've just put to me. The first one is you use the word, if you have been sentenced, and that's wrong. The sentence, the Constitution deliberately says, if you are at that particular point. So that's the first issue. The second issue is that remember, what we're after here is what we call the purpose. Now, we are saying the purpose of the proviso is to ensure that, and my learned friends are quite correct, that the disqualification only kicks in when there is finality. True. But we are saying that finality cannot only be achieved by judicial means. In the normal course of events, that finality will be achieved by judicial means. But if that finality happens, remember when we say is, what is the situation today? If the finality we know now is that the sentence was reduced. So that's the finality. The mere fact that that finality has been brought about by the exercise of the prerogative powers, which supersedes in any event the judicial power, is neither here nor there. And that is why in the preamble of our heads, we use this quotation from Sibiya. The executive can ordinarily alter the sentence of any convicted person after the judicial process has been completed. So that means that it is consistent with our constitution that the executive alters, reduces, whatever the word is, a sentence and of any convicted person after the judicial process is completed. The Constitution expressly empowers the President to pardon or reprieve offenders and to remit any fine, penalty, or forfeiture. It says that in one breath. There are provisions of legislation which empower the President to remit any sentence, to reduce, lessen, set aside, and to place people on parole and to unconditionally release convicted people from prison.
My last question, Mr.
Yes,
Mpofu.
thank you, Justice.
The respondents oppose the filing of a supplementary affidavit by the applicants. Do you persist in that opposition?
The filing of?
A supplementary affidavit.
I don't remember that.
So that means you don't, if there was, you don't persist in it anymore.
Did you find it? Oh yes. You're talking about the in this court, yes. No, this is what we say, Justice. It's tied up really with what I call the preliminary points. You know, it's all very well for us to want to protect the integrity of this court, but we must protect the integrity of all our courts. So, this notion, which is really repugnant, that these parties are here to seek clarity. That's what they say. Firstly, it's disingenuous, because if they wanted to seek clarity, then we shouldn't be here on an urgent basis. It can be done at any other time.
Please can you address my question?
Yes, I am. And all I'm saying is that for anyone to say they are seeking clarity when the Electoral Court has granted that clarity is disrespectful and contemptuous of that court. Because that court, and I'm coming to the supplementary affidavit point, what necessitated the supplementary affidavit is the fact that the IEC jumped the gun and came to this court before the reasons were given. So they knew prophetically that these reasons will lack clarity. How did they know that? How did they know that the reasons will lack clarity by jumping to this court? They would never have been in a position to have to do a supplementary affidavit if they had simply waited for the reasons, read them, decide whether they are appealable, and then come here. So it is on that basis that we object to that, because it has made us, and I can tell you this, Justice Theron, we literally, by the time the reasons came out, we had sat day and night as a team, drafting the answering affidavit to that original affidavit. And then just as we were about to file it, the reasons came. So we had to throw all that into the dustbin and then deal with the reasons, which is what the IEC should have done. So my objection, a very strong one, is to the notion that they were able to predict that there will be no clarity. If they had accepted the outcome of the Electoral Court, there would have been clarity. Everyone would know the objection was, the appeal was dismissed. That's clarity. Why? What other clarity do they need?
Thank you, Mr. Mpofu.
That's good.
Thank you, Deputy Chief Justice.
Mr. Mpofu, thank you for your submissions. I realize you've been on your feet for a while, and so I'll try not to prolong too much. I did want to you've put into the discourse strongly this notion that we must consider what the drafters contemplated, and I just want to be clear that we do not adopt an original intent approach to interpretation in South Africa constitutional law, and we shouldn't import it from the US, and the focus is really on the purpose of the provision. So in that vein, I asked the applicants as well, what is your understanding? You mentioned now the proviso, but how do you capture the purpose of Section 47(1)(e)? Why is that disqualification there?
Thank you so much, Justice Nicholas. Thank you so much. It has been suggested here wrongly that the purpose of Section 47(1)(e) is to disqualify so-called law breakers and all sorts of flowery language. Affirm the rights in Section 19. That's its primary purpose. And that is why it starts with these words. Every citizen who is qualified to vote for the National Assembly is eligible to be a member of the National Assembly. Full stop. Except that it's not a full stop. What they then say, except. In other words, having affirmed the the voting rights of all citizens. In fact, this is even wider than Section 19. If you look at Section 19(3)(b), it says every adult citizen. But this one doesn't, you don't even have to be an adult. So it's wider in a way than Section 19. It says every citizen who is qualified to vote for the National Assembly is eligible to be a member. In other words, if I have the right to vote in terms of Section 19(1), then automatically that translates into my eligibility to be an MP. That's the purpose of the section. But like everything in law, there are exceptions. So it says, yeah, then having put everyone under the same brush, we have the following exceptions. So already you are on the back foot because the purpose has been clearly stated. And then under those exceptions, it then lists the exceptions. And then in one of the exceptions, it creates another exception, which says, but for the purposes of this...
But you haven't answered why, what is the purpose of the disqualification? That's what we have to answer ourselves for someone who is convicted of an offence and sentenced to 12 months imprisonment. What is the purpose of that disqualification?
The purpose of that disqualification, I'm sorry, Justice Bilkis, if what I read out doesn't reflect the purpose. I think it clearly does. But the purpose of the disqualification, all the disqualifications for that matter.
No, the specific one.
Yeah. The purpose of that disqualification is to say that if someone at the point of eligibility is convicted or sentenced of an offence, then that person, at that point, will be determined to be ineligible. But the purpose of the proviso, which is really...
But that's, we're not getting to the proviso yet, and well, so you're not really showing what the purpose is of that, right? And the applicants have argued that the purpose is to indicate that someone who has committed an offence of a certain gravity, for instance, is not eligible to be a member of the National Assembly. If that is the case, right, how in conformity with that purpose, I'm trying to understand how your submission of allowing the President to alter that sentence and at any time after the sentencing, how does it meet the purpose of that proviso? Because the proviso, sorry, not the proviso, the purpose of that provision, because the purpose of the provision is to indicate gravity. And that indication comes from the judicial sentencing, not from any subsequent tinkering with the sentence.
I'm afraid you can't do that, Justice Bilkis. You can't determine the purpose of a provision by cutting it into small pieces. You have to, Ndumeni says you must do it holistically. So if you do that exercise, it's just a waste of time because you can say, what's the purpose of this comma and the purpose of this? No. Ndumeni says you have to look at the section as a whole. In fact, in certain situations, you have to look at the Constitution as a whole, for that matter. So you can't butcher it and do what the other side is saying. Because what they are really saying, Justice Bilkis, is the following. They're saying that that proviso says the following. Anyone who, after this section took effect, is convicted of an offence and sentenced to more than 12 months imprisonment without the option of a fine or outside the Republic, constituting an offence, and stop there. So they say it stops there. That's their version. So anyone sentenced to more than 12 months, like the Indian statute, is excluded. But you cannot do that. You have to, this is not the Indian statute. And the reason why it is not the Indian statute is because here, the Constitution goes further. It could have stopped there, like it did with the unrehabilitated insolvents. I'm sure there are all types of unrehabilitated insolvents, but it says all of them are in. But when it comes to this, it says, but, and that's an important word, but. No one may be regarded, and that's the deeming provision, I agree with my learned friends. The word regarded in statutory construction is to indicate a deeming provision. No one may be regarded as having been sentenced until, to paraphrase them, finality has been reached, which is a noble purpose, that until we know at that point what the actual sentence is. So that's why this thing of the imposed sentence is a non-starter, because and to be honest, none of the judges in the electoral court took that view, even Justice Yakub. She did it in a qualified way. But that's because the so-called imposed sentence runs directly against the purpose of this thing. Because if it had stopped at that before but, then it would have been the so-called imposed sentence. But it says, no, we want the what would have finally happened.
As I understand it, it's the imposed sentence which is final. Now, when a court sentences, it considers a range of factors that are judicial in nature, the gravity of the offence, the circumstance of the offender, the public interest, etc. The president, when she or he exercises their discretion in relation to remission, focuses on a whole lot of different factors. For instance, in this case, the presence of COVID, etc. Why would factors such as that influence whether you are disqualified or not from being in Parliament?
For two reasons. One is because when the president does that, that's why Justice Mudiba used the following phrase, legal effect. That's important. She says, what is the legal effect of the remission? And we cannot run away from that. The legal effect of the remission is the reduction of the sentence. If that is true, for better or for worse, if the legal effect of, as it was said in Smith, as it was said in Bushiko, that the legal effect of that remission is to reduce the sentence. I think in Bushiko, in one of the cases, it was from 24 months to 16 months or something, or years. But those cases said that the legal effect of the remission was the reduction of the sentence, and that was confirmed in Sibia. That is, it says in Sibia, alter the sentence. So it can be clearer than that. So if the legal effect is to alter the sentence by reducing it, then that is the legal effect. It is immaterial, Justice Bilhis, that legal effect has been achieved by superjudicial means, for lack of a better word, or by a process where the president is allowed to override, just as it does with pardons, by the way.
And I want to ask you about that, because you made an attack on the pardon power and that power in terms of 84.2, and I tend to agree with you that that's an extraordinary power.
Yes.
But it seems to me that that would actually run counter to your argument that we should actually limit the power of pardon to only pardons, and we should ensure that remissions actually have a less extensive effect, rather than interpreting in the way you're suggesting that preserves that, as you put it, colonial heritage. We should rather try and restrict the lack of that very wide power itself.
I understand that. No, you can't do that. That's not your job. Your job is not to rewrite the Constitution. Yes, it's to interpret it. So whether it was a good thing or a bad thing to have remission mentioned together with pardon is something that we can debate. I've put my position very clear. But your job is confined to one thing and one thing only, which is to interpret. And in that process of interpretation, whether you like that the prerogative powers or you hate them, as I do, they are here now. And they cannot be limited only for Mr. Zuma, because that would be another gross violation of his right, that for everyone else we accept the drastic powers of the executive. But for Mr. Zuma, we're going to restrict them. Why?
One last point from me. As I understand it, you make the argument that civil contempt is generally not a crime to which Section 47(1)(e) applies, given the lack of conformity, as you've said it, with various procedural rights in Section 35. But civil contempt essentially is a crime that addresses the disobedience to court orders, which is an essential feature of the rule of law. And we know the rule of law is also mentioned in Section 1 of the Constitution. If the purpose of Section 47 is partially to protect democracy, as we have seen from various authorities, against those who undermine the rule of law, why would this crime specifically not be one that is included within the domain of Section 47(1)(e)?
Okay, because there is a reason why, this is the most difficult concession I've ever had to make. Every time I try to make this concession, I'm brought back to it. I have considered in the electoral court here, and I'm considering it again, that contempt of court is a crime, right? And even in the electoral court, I was taken to task for this. I said, no, I can concede what I want to concede. So that's not the debate. The debate is this. And that concession, by the way, I do it under advisement, because it's not as simple as that, but let's take it for it comes. The issue is not that. There is a reason, Justice Bilhitz, why the crafters of the Constitution did not discriminate or specify which crimes are this or that or the other. They simply say an offense that is where the sentence has been 12 months. The reason is to prevent this kind of debate. We can't now say, oh, just because it's contempt, oh, because it's car theft, because it's that. No. They wisely and deliberately did not want to enter that debate. And the reason is very clear, because what we call the effective sentence or the ultimate sentence is an indicator. And that is why it's important, Justice Bilkins, that we look at I don't have time to do that now, but the court in its own time will look at the actual remission gazette. That remission gazette has got 13 qualifications of who will not benefit from it. So even if you are one of those people, even if your sentence was just about to end next month, you will not benefit. But if you are like Mr. Zuma, and that's because of the drastic nature, as you correctly say, but if you are like Mr. Zuma, and they said you are a low-risk offender, and you are not a danger to society or whatever, then you will benefit. What does benefit mean? Benefit means you get a discount. You get part of your sentence extinguished permanently. And that is why Justice Yakub's qualification doesn't hold water with respect. Because the fact that it's not pinned down to Mr. Zuma is irrelevant. But it is pinned down to a category to which he belongs.
Thank you, Mr. Pope. I think we're recovering material.
Okay, yeah, thank you very much. I appreciate those. I welcome those questions.
Mr. Mpofu, well, I hope I'm the last one.
Well, I can't say that I agree, but I do.
The question that I want to ask you is on two one on bias,
Yes, Justice Mato.
and you submitted that if we are with you on bias, the rest
end.
falls flat. That's the end of the matter.
Correct.
The bias is underpinned by what it is alleged that Mrs. Love said when she was being interviewed.
Yes.
You referred us to volume 4 at page 272 and going to 273.
272.
Yeah.
Yes, Justice Mato. Am I right?
And this is a news article.
Yes. That's the original one. Yes.
Yeah, and the complaint of the respondent is that the IEC has confirmed that former President Zuma does not meet the requirements to register as a candidate to stand in this year's elections. Turn over to the next page,
273.
273. One, two, three. In paragraph 3, it says, Commissioner Janet Love, it's paragraph 2. The IEC or Electoral Commission on Thursday confirmed this. This is what I've just put to you. When asked at a press briefing whether Zuma could be included on a party list for election to Parliament.
Right.
Commissioner Love said the IEC was bound by the law and the Constitution in terms of who was eligible to run for the political office. She's been reported as saying, this is the law, this is the Constitution.
No problem with that.
And there's a quote, I think it may be attributable to her.
Yes.
And it says, that excludes anybody who has been given a sentence that was not subject to any deferral. And in that sense, it is not ourselves, meaning the IEC, but the laws of the country that would stand as an impediment for that candidacy. Except for this, is there any other reference or any other statement attributable to Mrs. or to Commissioner Love that you are challenging as forming the basis for her recusal?
Yes.
And that the IEC as an entity was biased?
Yes. Remember, let's start with the original article which was attached to the notice of appeal. Remember how I think it was annexure D. Yes. So we must look at what the complaint was. It's page 258. Oh, yes. It says the commission as a whole. Okay, I'm sorry. Oh, okay, just a moment. I'll wait.
258, you said?
258, yes.
Yeah.
Yes. I won't read the first part to save time. But what you say about the article, it says an illustrative copy of a media report relating to this said statement by Lindsay Dentlinger of Eyewitness News under the heading Zuma not eligible to register as a candidate, IEC. A copy thereof is annexed here to enmarked annexure D. When we say illustrative, we could have attached every article that was reported on that. But we're saying this illustrates or exemplifies what we're talking about. Now, at that point, the issue was as follows. It was whether, at least we thought the debate would be that maybe the question was not the question that was put about specifically Mr. Zuma, to support this notion that it was just a restatement of the law. But we said, look at the first line. It says, the Electoral Court Commission has on Thursday confirmed this when asked at a press briefing whether Jacob Zuma, right, could be included on a party list for election parliament. So it was not a question about the law. It was a question about Jacob Zuma. And then she then says, so that's the question is asked specifically. It's like I was saying in that example. If you say to a judge, is Mr. Muela guilty or not guilty? And say he is. It's not, you can't say, well, it's about the Criminal Procedure Act. It's about him. Then, so because you must read this in context. Then you go to Commissioner Janet Love said the IC was bound by the law and the Constitution. Who can quibble with that? That's fine. But here's the part. That excludes anybody who has been given a sentence that was not subject of any deferral, and in that sense, here's the important. It's not ourselves, but the laws of the country. That would stand as an impediment for that candidacy.
So what's wrong with it?
That candidacy, in the context of this, cannot mean anything else but Jacob Zuma. That, when you say, if it's the law that would have, that is against that candidacy, the one that you have asked me about, not about Mr. Mpofu, not about Mr. whoever it is.
But isn't that the whole context? It's about whether Mr. Zuma would be able to stand or not stand.
Yeah.
And her response is, the laws of the country and the laws of the Constitution, and the Constitution says, if you have this impediment,
you can't stand.
You can't stand.
Exactly.
And I just want to know what is wrong with it.
No, there's everything wrong with it, Justice Matopo. If you say that the laws of the country say that Mr. Jacob Zuma cannot stand, let's say you say that because that's your view, that's fine. You are entitled freedom of expression. You can say whatever you want. But you cannot tomorrow sit as an arbiter of that very question. You can't. You know. So if you say, you might hold a view about Mr. Zuma's eligibility or not eligibility. Either you keep it to yourself, but if you're going to express it, then by that act you are disqualifying yourself from pretending to be a neutral arbiter the following day. Imagine if an arbitrator was to declare which of the parties is responsible for this or whatever the dispute is. And then the following day he says, okay, now you can address me. The party who's holding a newspaper, they say, but Mr. Arbitrator, I see here, you said the car does not belong to me. And he says, no, I was just stating the law. What is that? No, you can't do that. So that's the first issue. The second issue is that mercifully, our learned friends at paragraph 20 of their affidavit, where we thought they might fudge the issue and try to get out of it, actually assisted us. That is page 281. They say that
Page,
was
what page?
281 at paragraph 20.
In the affidavit of Moepi.
Is the answer? Is their answer to our yes? Thank you. It says that was not prejudging Mr. Zuma's eligibility to stand in the election, and this is what they say. Ms. Love simply stated the correct legal position. Moreover, her statement was made in response to a question about Mr. Zuma's eligibility. I mean, this is the IEC itself saying under oath that Ms. Love's statement was made in response to Mr. Zuma's eligibility. They might as well have said under section 47(1)(e). And then neither Ms. Love nor anyone raised the Mr. Zuma's eligibility on their own accord. That's irrelevant. So they confirm that she was talking about Mr. Zuma's eligibility. And all I'm saying, Justice Matopo, is that that is the very question which then serves before her. Number one. Number two, it turns out that they actually lied about this not being a confirmation of an existing position. Under oath, So the court cannot really want to use technicalities to run away from a criminal offense. The people who say that the commission did not decide, at least not before the decision, that Mr. Zuma is not eligible to register as a candidate. But a week before, they said it's official, former President Jacob Zuma cannot be the president of the country, and so on. Therefore, this provision, then they quote section 47(1). Therefore, this provision renders former President J.G. Zuma, not some other person, disqualified to be on the list of any party contesting an election or to contest as an independent in the upcoming elections. Really, can it ever be clearer than that? That this was, Justice...
So the short submission is, if we are with you on that point, the decision of the IEC is tainted because of the bias of Ms. Janet Love, and also the passage that you've referred to us in the affidavit.
Yes, remember,
on that basis only,
yeah.
We don't have to consider the other points.
That's quite a thing. If on that basis only, that basis is more than enough. If someone has lied to this court under oath, I don't think it can be described as only. Because, that's the worst thing you can ever do. But let's assume it can be, you could say, well, it's like saying, I'm sentencing you to murder because you only stabbed someone. It can be. What we're saying, Justice Matopa, is very simple, simply this, that these transgressions, the original transgression of prejudging the matter, and this transgression that has now come out. And remember, this current transgression is provoked by the fact that Ms. Love now in this court, unlike in the previous court, puts a confirmatory affidavit, in other words, confirming these lies. And then we say, okay, well, if you're going to accept her answering a confirmatory affidavit, surely, in terms of audi alteram partem, you must give us a chance to refute that lie. And we refute it with evidence that shows that it is not true. So it's not only, it's one of the most egregious forms of litigation. Sorry. Justice for that.
Yeah, maybe I'm wrong to try to interpret what my colleague Justice...
We're not interpreting anything today.
No. Justice Matopo said, but I understood the only, not to make light of
thank you.
The point we're making, but rather to say that this point puts paid to the IEC's case. That's how I understood.
Oh, yes. No. Thank you. Then I'm sorry. If that's what the question would be, yes, of course. Remember, we said all of the matter. So if the electoral court had found in our favor on bias, that would have been the end. Or if they had found in our favor on ultra-virus, that would also have been the end. So if that was the question, yes, we definitely, in other words, if the only means you can decide the case only on that point, yes, then the answer is definitely yes. But what I was...
You've answered me.
Yes.
Yeah, can I just finish my last question?
Yes, of course.
Is it your submission that the judgment of the electoral court can exist side by side with the judgment of this court, a contempt?
Well, it was not this morning, but it is now, because you have found, I'm reading between the lines, that this case is not about any interpretation or judgment, so to speak, on the other one.
Perhaps let me put it very clear. Is the judgment of the electoral court saying what this court said in the contempt application?
No, it's not it's not saying the same thing, but what it is saying, Justice Matopo, is this. it's like, let's say this court had said that someone is not fit to be a lawyer or something at a particular point in time. What the electoral court was saying is that, does that judgment, as it stands then, for example, mean that this person now is not eligible to be a lawyer or a doctor or whatever it is? And it is in that sense that I was saying this morning, it is inevitable that this court has to interpret that judgment, just as it was inevitable for the electoral court to interpret this, the judgment of this court. It's inevitable.
But if the judgment of the electoral court makes findings that cuts across findings that were made by Kampepe J in the contempt of court, can it exist side by side with that judgment?
Yes, in the following manner, Justice Matopa. If the question before the electoral court, for argument's sake, was whether the committal for contempt by this court was committal for contempt, and they say no, it was not, then they would be second-guessing this court. But that's not what they were doing. What they were doing was to say, is that committal for contempt of court, for the purposes of the thing before us now, which is 47(1)(e), a conviction per section 47(1)(e). And that's why
can they do that?
Yeah, of course they can. Because
but doesn't that seem to nullify the judgment of the contempt of court judgment, if it does?
Yes, it would nullify it in my first example. But in this second example I'm making, it doesn't nullify it. Because it does something very banal and simple. It says, what does the word convicted mean in 47(1)(e)? Just like that. And does it mean a conviction as contemplated in section 35 or not? If it does, then this conviction cannot be the one that was intended. I don't want to go to intentionalism, but let's use purpose. Then the purpose of the intentionalism is actually brought by the wording that says contemplated, because obviously that brings in that element. What they were saying is that the purpose of the disqualification did not include that which the Constitutional Court did, rightly, let's say, for argument's sake. Constitutional Court did what it had to do, it was correct, it was okay. But that which it did does not translate, and that's where really the case becomes simple.
But if you read the judgment of the electoral court on its own,
Zondi JA.
Yeah, on Zondi JA, and without comparing it or analyzing it with the judgment of this court, the debate that you and I are having, it's not in that judgment.
No, it is. It is. They say...
In paragraph 51, Zondi does not even interrogate the issues as extensively as you are.
Yes. No, but...
So one has to assume that this is what he says.
No, Justice Matopa, with respect...
am I wrong?
No, with respect to you are. That is why I said, let's use the issue of appealability as a proxy. The issue of appealability must not be used as a red herring to hone into that issue. It is a proxy for the denial of the 35(3)(0) right. But it is also a proxy for the denial of all the other rights in 35(3). And therefore, what the electoral court was saying was that a so-called sentence which does not conform with 35(3)(0) and S versus Rance and S versus Twala and all these other cases which say that there must be a reappraisal of cannot be a sentence that was contemplated in 4713. In doing that, they were not denying the clear fact. If they were denying that clear fact, they would never have gone to the remission point, because what would have been remitted? Nothing, because Mr. Zuma was free. No, that would be absurd. They accept that this is what happened. And that's why they go on to say, having defined the conviction is, the question is simply this, Justice Matopo. Can anyone here say that, and I'm using the language of contemplation deliberately, that it was within the contemplation of the drafters that a conviction which does not conform with the Bill of Rights would pass muster? Or, to put it differently, as Cameron J.A. put it, can anyone contemplate that a committal for contempt in civil proceedings would result in a previous conviction? And in both cases, our respectful submission is no. So that's all they were saying. So let's assume they were interrogating that question only, whether it's a previous conviction. If they found that it is not, they would not be second-guessing this court. They would simply be saying a committal of this nature does not belong to the SAP 69. Without that does not mean that then they're saying that committal was wrongly granted. No.
So the conviction and the sentence, you would characterize them as not ones that fall within the realm of the SAP 69?
Yes. No. Yes. No, I'm saying... yes, I'm saying this, that very question that you're posing to me, Justice Matopo, is the question that was left open by Justice Cameron in Faki. And all I was saying, I'm not taking it any further. I'm not even answering that question myself. I'm simply saying, by the mere fact that Justice Cameron, in that matter, saw it fit to leave that question open and to relate it to Section 35, which is what I have done. By that act alone, it shows that it's not a straightforward issue. Because if it was, he would have said, he wouldn't even have referred, he would have said, these people, I don't know what they were smoking. They come and say, is the conviction a conviction? Obviously it is. But no, he entertained it exactly because it's not as straightforward as it looks to the naked eye. He interrogated that question and posed it posited it, as it were, for a future...
But wasn't it answered
in which matter?
In the Rampepe judgment?
No.
My brothers and sisters said?
No, it was not answered because that's why I was saying
or
to
it did
Justice...
not arise?
Well, I don't know if this court... Remember, in the magistrate court, what happens? You would know, Justice Matopo. A long time ago, we used to do these things together. But in the lower courts, even the high court, let's say, when the sentencing happens, then that court, it is the duty of that court to then enter the record, so to speak, and process this SAP 69 and so on. That's why Justice Cameron says, what mechanism would be employed? Because this would be a civil court now. A civil court, does it have the mechanisms to enter a sub 69? And I doubt it. I won't put it higher than that. I doubt if this court, after the Rampepe judgment, took those steps.
You prove a previous conviction by your SAP 69, if indeed there are.
Correct. And if it's not there, you can't.
Okay.
Okay.
Oh, poor Mr. Mpofu. Thank you so much. No, I'm just commiserating with you.
Well, no. No, you don't have to, Deputy Chief Justice. The only problem is that I have this flu, but it's gone now. I think the adrenaline kicked in. No, we indebted to the court for the interaction, and the order that we seek is obviously whether it is based on the counter application is gone now, whether it's based on the acceptance of that the conviction was not a conviction for section 713, or that the sentence was not a sentence for the purposes of that section, or if the court doesn't like those, the mere fact that the remission, the presidential remission of sentence, obviously had the effect of reducing the sentence, assuming it was a normal sentence, quote unquote, or what Justice Kambebe called a conventional sentence. Assuming it was those, the effect of the remission would have been to reduce it. If the court is against us on all those three issues on the merits, we still say that the court will have a duty to examine where the IEC derives its power to deal with the holding of office, which is a province of the National Assembly. And if they are against us even on that, then the bias point with respect on these facts is unanswerable, because I don't think there's anyone who can ever say that a body, a so-called independent body at that, can do what was done here. So on either one of those bases, we respectfully submit that the appeal be dismissed with cause.
Thank you, Mr. Zuma.
Thank you, Justice.
Deputy Chief Justice, I mean, it's 15 minutes past 8, and that's not a joke.
Yeah.
So I don't know what you want to do, whether you want me to just press ahead or you want to take some time.
Ahead,
all right, thank you. I'm going to try to really be succinct. I think that it's been oppressive to all of us. So the first point is the purpose of the disqualification. We've dealt with the purpose of the disqualification in our heads of argument, and we've referred to paragraph 168 of the Venice Commission report. Nothing to add there. The second question is whether or not contempt of court should be among the offenses or the crimes that are hit by Section 47. We say yes, and probably even more so for contempt of court, because contempt of court, you will recall, is a crime against the administration of justice. That's really the essence of contempt of court. And if there was a case where Section 47, which is people trying to become our public representatives, if there is a case where Section 47 should apply, it is contempt of court. Because it's a crime against the state, it's a crime against the administration of justice, it is a crime against the rule of law, it is a crime against the Constitution. And the primary duty of MPs is to uphold the rule of law. So their intentional defiance of court orders is inimical to that purpose. So in this debate about whether or not contempt of court should be within or outside Section 47, there is a very strong normative case that it should be within the ambit of Section 47. And we see this court in paragraph 87 of the contempt ruling, where it makes the point clear. It is almost crying for help when it says, if the impression were to be created that court orders are not binding or can be flouted with impunity, the future of the judiciary and the future of the rule of law would indeed be bleak. So if we rewarded people that are guilty of contempt of court would sit in parliament, imagine what would happen to the future of the rule of law. The third point is around this double punishment theory. There is no double punishment. This is not a punishment. It is akin to the reasons for the striking of a lawyer or an attorney or an advocate from office. The reasons have nothing to do with expressing a moral opprobrium. in relation to what they did to their clients, whether they stole money or not. The reason is to protect the public. Particularly where at the time of the striking off, they still display no signs of any reformative character. So the same object is achieved by Section 47. It is not a punishment against Mr. Zuma. It is simply to protect the public and the institutional integrity of Parliament. Number 4, there is the issue of ripeness. Let me spend a little bit of time on this. The powers of the Commission have been much discussed. It is Section 30 of the Electoral Act that applies. Section 30, subsection 1A, says that any person, including the Chief Electoral Officer, may object to the nomination of a candidate on the following grounds. 1, the candidate is not qualified to stand in the election. Now, that phrase, not qualified, tracks back to Section 47 itself, because Section 47E, the last sentence, says a disqualification under this paragraph ends 5 years after the sentence has been completed. So it's a disqualification provision. But it is put into operation by Section 27, subsection 2, subsection A, which says that if you want to contest an election, you must submit a list. That list must contain an undertaking signed by a duly authorized representative of the party, and it goes on and on. That undertaking is contained in page 147 of the records. So you will see at page 147 of the record. That is what that undertaking is. It's Appendix 2. This is what it says. Justice Gamble, you raised this point, but never really went to the actual annexure. But this is where it is at page 147. This is what you undertake. I declare, under 8, I declare that I have confirmed that each candidate on the list is qualified to stand for election in terms of Section 47 and or Section 106 of the Constitution. Section 47 applies to the National Assembly. Section 106 applies to the provincial legislature. So this is all a pre-screening process prior to anyone being nominated for the National Assembly. So plainly, it's an obligation of the Electoral Commission that it must screen candidates for qualification under Section 47 of the Constitution. We have made further submissions in our heads of argument in which we point out that there is a fundamental conflict in what is being submitted on behalf of MK, because they say that you qualify, you are eligible to stand for an office that you cannot hold. And they say, well, the solution is Rule 13 of the rules. When they have to explicate what Rule 13 is about, what they say is that in the first meeting of the newly elected National Assembly, the first order of business is the election of the Speaker. But the question is, who is electing the Speaker? In order for you to elect the Speaker, you must be eligible to be in the Assembly. So they are not answering the question, they're begging the question. So there is a straightforward answer and not the contortions being suggested by MK. Number 5 is the question of bias. Now, there are 2 documents. The first document is at page 272 and 273. That's the document that quotes Ms. Janet Love. And the actual quotation is at page 273. And it is, this one is mine, yeah. So this one says that, she says, that excludes anybody who has been given a sentence that was not the subject of any deferral. And in that sense, it is not ourselves, but the laws of the country that would stand as an impediment for that candidacy. So it's a neutral statement that doesn't really take matters anywhere. Then what happens is that when the matter came before this court, new evidence was then introduced, which is at page 493. It now appears that the fulcrum of the bias case is on the new evidence. So page 493 and 494 was not before the Electoral Commission. It's new evidence introduced in this court. And it's introduced without an application for the introduction of new evidence. So it's impermissible. It's pro non scripto. It should not be taken into account at all. So the only issue that was before the Electoral Court is page 272 and 273. And as I say, it's a neutral statement that takes matters nowhere. And the Electoral Court, at least on this score, cannot be criticized. And you will disregard entirely the supposed references to page 493. We didn't respond to it.
Mr. Zuma, sorry to interrupt you. Didn't the applicant, in terms of an additional affidavit by Ms. Love, and I forgot to ask you about this earlier, also introduce a new affidavit? And my question is, this is an appeal.
Yes.
Shouldn't it be decided on the basis of what was before the Electoral Court?
Indeed. We agree entirely with that. You can disregard the confirmatory affidavit of Ms. Love, and you will be left with one document, which is page 272 to 273. We agree fully. I'm out of time, Justice, Deputy Chief Justice. I have only one more point, so if I could ask for a minute. Thank you. It is in relation to the case of Disanaike. We listened carefully to what is being suggested. It's actually not correct. The correct finding is at paragraph 8.5 of that judgment. What it finds, what the actual committee found, it did not find that the principle of excluding candidates who have a criminal record is necessarily unfair. It found that the period of exclusion in that case, which was 7 years, was disproportionate. So it was decided on the principle of disproportionality. So you will see this where it says, given that these restrictions rely on the author's conviction and sentence, which the committee has found to be arbitrary in violation of Article 9, paragraph 1, as well as the fact that the state party has failed to adduce any justification about the reasonableness and or proportionality of these restrictions, the committee concludes that the prohibition on the author's right to be elected or to vote for a period of 7 years after conviction and completion of the sentence are unreasonable and thus amount to a violation of Article 25B of the Covenant. So it was on the disproportionality of the period of disqualification. I have already made submissions in relation to what the remission means and what the appeal proviso means. There is no point in repeating those. Deputy Chief Justice, I want to thank the court for the patience, and we have no more submissions to make.
Thank you very much, Mr. Mbete.
Sorry, Mr. Chair, I promise you I'm not exercising my right. I would have normally had a right to reply on the cross appeal, but I'm not exercising that. Just wanted to make a reference that I had promised to Justice Bilkis. It's at page 223, where I was talking about the issue of the heading special remission of sentence for certain categories. So that's what I was saying, it's not a general, of sentence offenders, correctional supervision, paralease. And then there's the list of 13. And in that list, it says sexual offenders, murderers, attempted murder, crimes, criminal lifers, child abuse, and so on. And they don't include contempt of court.
Thank you. All right, thank you all so much for your submissions, and we do apologize for keeping you for such a long time on a Friday. Judgment is reserved.
As court pleases.